the first part that we've got to understand is the types of territory and the layers of it. So to begin with, you've got three basic types of territory, which is land, water, and air. So any discussion on territory would eventually begin on the types of it. And each of these three types are going to have two layers to it. One would be an external layer, the second would be an internal layer. An external layer is largely a national or an international layer, and an internal layer is a subnational or a subunit layer. Now, when we speak of land, we understand from an external point of view, there is essentially a political dimension to external land and an economic dimension to external land. When we say there is a political dimension to external land, we are effectively referring to the international land boundaries that have been defined for India. And India's international land boundaries have largely been a result of the partition of India and a result of India's colonial history. So therefore, our international territories or our national territories have largely been marked for us by our colonizers, the very British. In addition to this, due to the partition, we've also had a significant change and a significant redrawing of our international or national territory. Even the partition and the territorial division of the partition was actually executed through the British. So that's something to remember. From an economic point of view, you are very well aware of national income accounting. And in national income accounting, there is a concept of a national territory of India and the domestic territory of India. The domestic territory of India is the physical land boundary of India, whereas the national territory of India is the territory that ought to be of India. So for instance, the US Embassy in India is a part of the domestic territory of India, but the national territory of the US, because there is an economic bifurcation. Similarly, when somebody from India decides to go abroad and send money back to India, so that person's sending money back to India is added to the Indian income. So what happens is, if you want to go from domestic to national, you add what is called a factor income from abroad. So that's an economic way to look at it, which is beyond the purview of this class. So when it comes to national territories, we have very clearly identified our international borders. And whatever India is rightfully claiming to be its international border is in fact our international border. Now, it is important because when we discuss international territories, we also sort of get into the concept of what is a disputed territory. Now, it is very important to understand that a disputed territory would be a territory only for two reasons. One, if India has accepted foreign intervention and a discourse or a discussion on that territory or negotiations on that territory are happening at an international forum, or two, India officially recognizes the territory to be a disputed territory. So to make myself absolutely clear, whether it is the area of Exai or it is the area of Pakistan occupied Kashmir, or as it is called colloquially Azad Kashmir, these are all parts of the national or parts of the territory of India. They're all parts of the physical territory of India. There are no two doubts about it, because we do not recognize POK or Aksai as a territorial dispute in any form. There is a possibility that Aksai is administered by China, is occupied by China, but that does not mean the territory does not belong to India. Now, once you have looked beyond, we now look inside. So the first thing that we do in India is we have a political division. And this political division is that we divide India into states and union territories. Now, what is important to note is, as far as Part 1 of the Constitution is concerned, which takes care of union and territory, what we specifically refer to is the international territory and, of course, states and union territories. Categorically, Part 1 does not deal with any other form of territory. Now, within these subnational units called states or union territories, or these provincial units called states and union territories, you can have an administrative division or a representative division. A representative division could effectively be an MP or an MLA constituency, whereas an administrative division could be a district, a sub-district, a block, or a village. Sometimes a combination of administrative divisions could be integrated into the third layer of government, which is local self-government, and you could have urban municipalities and rural panchayats. So therefore there could be a rural and an urban bifurcation. Similarly, you could have some specific territories identified for dedicated welfare. For example, there could be an issue of, say, the 5th schedule or the 6th schedule, or say special states, or say special areas under Article 371A onwards. So these are subdivisions which, of course, in some cases the Constitution deals with. But those parts are not dealt with as far as Part 1 territory is concerned. Having said that, you can also have certain territories earmarked for security reasons. For instance, a fairly discussed law called the Armed Forces Special Powers Act also calls for a specific territory or a specific division of territory or demarcation of territory called a disturbed area, which can also be earmarked as a territorial division but based on security. So there could be multiple ways to look at internal land territory. And in fact, because land is the most tangible, what effectively ends up happening is it is easy to identify different forms and layers of territory because it's easy to physically bifurcate as far as land is concerned. Then you have waters. Now, waters could be international waters and national waters. As far as international waters are concerned, there is a UN treaty called the UN Convention on Laws of the Sea. The UN Convention on Law of the Seas is something that India has ratified to, which means India abides by the international division of international waters. And I have simplified a bit. There has been a prelims question from here before as well. There are largely 4 types of international water boundaries, and these are calculated in nautical miles, which is about 1.5 to 1.8 odd kilometer. The number is not important, but they're calculated as distance from the coastline. So the closest to the coastline is territorial, or it's called territorial sea. Now, territorial sea is full sovereign territory of the country. You could in fact even call it like the domestic territory of the country, which means in the territorial sea, which is about 12 nautical miles from the coastline, what you would generally observe is that all domestic laws, all domestic applications would be completely compliant. And while yes, foreign vessels do have the right to pass through the territorial sea area, but in international law, you call it an innocent right to passage, that you're passing through just because you're passing through, and there are no larger ideas or funny thoughts while you're passing through the territorial part of it all. If you go another 12 nautical miles beyond this, which is about 24 nautical miles from the coastline, you would enter what is called the contiguous zone. Now, the contiguous zone is slightly diluted than the territorial zone. what happens in the contiguous zone is that it has limited jurisdiction of the country, which means the country will have jurisdiction largely for criminal law enforcement, for upholding certain basic law and order norms. So, for instance, you could have the country supervise over customs, over violations of certain rights, over human trafficking, immigration, even taxation provisions, and also polluting elements. So, all of the local laws concerning customs, trafficking, immigration, taxation, and pollution would apply till about 24 nautical miles. So, you would still have some form of national sovereignty, a very important form of national sovereignty, but still not full national sovereignty. If you go a little beyond and you reach about 200 nautical miles from the coastline, what you would enter is called the exclusive economic zone. Now, the exclusive economic zone, as the name suggests, is economic in nature. Now, this means the country would have exclusive economic rights over natural resources. Now, these natural resources would effectively include things like fishing, things like mineral exploration, and so on and so forth. And if you go further beyond, you entered what is called high seas. Now, high seas is a concept which is beyond UNCLOS, which means that it is generally considered to be an entity or a resource equally shared by all countries. And as far as high seas are concerned, you have a dedicated organization, very important from an environment point of view, called the International Seabed Authority. The International Seabed Authority identifies this area, in fact, as the area. And in this area, you would generally have commonality of resources, commonality of ownership, and of course, commonality of responsibility to ensure that there is no overexploitation in any manner. None of this is referenced in Part 1, Territory of the Constitution of India. When we look at internal waters, we would largely be looking at water bodies. Now, what generally happens is internal waters in India tend to be a federal issue. Now, when we say it tends to be a federal issue, it means there are often times where a river would flow from one state to another, and we have historically seen several river water sharing disputes between the center and the states, between the states in fact, and the Constitution very specifically sets up an interstate water disputes tribunal. There was a law also recently passed, and the tribunal specifically prohibits the intervention of the Supreme Court when it comes to interstate water disputes. You can go to the Supreme Court if the order of the tribunal is not being enforced, but the Supreme Court directly does not hear or does not have jurisdiction over interstate water disputes. But any other interstate dispute technically is the original jurisdiction of the Supreme Court. Now, this becomes extremely important. Again, Part 1 of the Constitution, Territory of India, does not deal with these internal water sharing issues. They are dealt with separately in another part of the Constitution, fairly close to federal and center state relations. Now, because we live in a globalized world, there is of course the third element of territory, which is air. Now, air becomes an important notion, especially from a geopolitical point of view. And there is something called the Chicago Convention, which identifies what is called the national airspace. India has also ratified what is called the Chicago Convention. Now, the Chicago Convention identifies what your national airspace is, which means if there are two countries which are neighboring, and let us say the ties have roughened up, then what generally happens is the country closes down their airspace for the other country, which means flights cannot originate from these, and maybe you'll have to bypass the airspace of the country, which is one of the fundamental reasons why airspace becomes a very important instrument in geopolitics. As far as local airspace is concerned, or federal airspace is concerned, there is no such concept. However, because air tends to get polluted, you would hear of issues like stubble burning, where states would be blaming each other for these cases, but that's not from a legal point of view. That's largely from an environmental point of view. That's largely from a policy point of view. But this is generally the makeup of what effectively is called the dimensions of territory. Now, once we understand the dimensions of territory, we must be looking at the layout of it and certain key concepts, which is a part of policy overview. Now, this is conceptual and therefore needs to be paid attention to. When we refer to the constitutional layout, it means how the constitution has dealt with territory. Part 1 of the constitution is titled Union and its Territory, and part 1 contains 4 articles, article 1, 2, 3 and 4. These articles can be called enabling provisions, which means they give you the terms and conditions, they give you the do's and don'ts, they give you the procedure to make territorial changes. So when you make territorial changes, you don't change 1, 2, 3, 4. What happens is, because of 1, 2, 3, 4, you change something called Schedule 1. Now, Schedule 1 will contain the names of states and union territories along with their area, and that's pretty much it. So the actual territorial change would effectively happen to Schedule 1, and that's a very key concept, which leads me to certain key points. This means, as I was saying, all territorial changes effectively happen to Schedule 1. In fact, Articles 1, 2, 3 and 4 have remained unchanged since the commencement of the Constitution. We have added Article 2A and then we have removed Article 2A in the context of the nature in which Sikkim became a part of India. So when we added Article 2A, Sikkim had become an associate state of India, but when Sikkim became a full-fledged state of India, you had to remove Article 2A so that the Sikkim would become like any other state in India. So Articles 1, 2, 3 and 4, as I said, are enabling provisions that allow you to make changes to Schedule 1. So all territorial changes, whether it's external or internal, would effectively happen to what is called Schedule 1. Now, if you could apply this a little bit more and correlate it to your sub-national political divisions, which means India basically is comprised of states and union territories. So whatever the territorial change might be, even if you're bringing territory from outside, you would either add it to a state or make a new state, or you would add it to a union territory or make a union territory. The change that would actually happen would be to the territory of the state or the union territory. So therefore, it becomes extremely important to understand that all territorial changes happen to Schedule 1. And no matter what the reason for the territorial change might be, the change would effectively happen to states or union territories. Now, different types of territorial changes would require different procedure, and that's something that we will get into. And this different type of territorial change is specially to deal with when we give away a territory to another country, or a specific type of territory to another country. But this would require a different procedure. Where would the change still happen? The change would still happen to Schedule 1 and nowhere else. So all changes happen to Schedule 1. Depending on the type of change, you will use a different majority but the change will always happen to Schedule 1. Now, because of a trickle-down effect, this territorial change could often lead to other changes, which means when you're adding or subtracting the territory of the state or the union territory, which is a political territory, it could have an impact on the representative territory. So if you're dividing a state into two, you would effectively also be dividing the number of representative constituencies. And the Constitution very specifically mentions one kind of representative constituencies, which is Schedule 4. Schedule 4 contains the number of seats that each state would have to the Rajya Sabha. Now, if you're changing Schedule 4 for territorial reasons, for example, you are bifurcating Andhra Pradesh into Andhra Pradesh and Telangana, this means the number of seats Andhra Pradesh had to Rajya Sabha will decrease, and the number of seats that Telangana would have to the Rajya Sabha, obviously from 0, would increase. This would also require a change to Part 4. But this change to Part 4 is not because of anything else. It's because of a territorial change. So if it is because of a territorial change, it means it will be dealt with the same procedure of a territorial change. That's the key part. So often you'll see the same Reorganization Act would change Schedule 1, and because of Schedule 1 will also change Schedule 4. But if you remember the majorities lecture, if you are changing the number of seats to the Rajya Sabha for any other reason, for example, you change the criteria, you change the formula, then of course it would require special majority 3. But if the change to Schedule 4 is because of a territorial change, then the change would in 99% of the cases be a change through simple majority, an ordinary territorial change. So that's the third concept that we must be aware of. And fourthly, and this is the important part, territory is an instrument of sovereignty, which basically means when we are dealing with the notion of state, and we've discussed the modern notion of state includes territory, sovereignty, government, and people, which means territory and sovereignty are closely interlinked. Territory and sovereignty will have a very close association. So this means any change of territory is effectively having an impact on what is called sovereignty. So this means a territorial change could also be looked at from a breach of sovereignty perspective. So if a territorial change could be looked at from a breach of sovereignty perspective, and the word sovereignty is only and only mentioned in the preamble, it would lead to a larger discussion on the status of the preamble, on whether the preamble is a part of the Constitution or not, which is why territorial changes which affect sovereignty have an impact on the meaning of the word sovereignty, which is in preamble, which is where you have a larger question, whether the preamble is a part of the Constitution or not. And that is why when you hear of cases like Berubari Union, in the Berubari Union, you will see the case to be significant for territory, but also to be significant as a milestone to determine whether the preamble was a part of the Constitution or not. So that is the duality of the role of territory. It helps you understand territory, and it also helps you understand sovereignty and whether the preamble is a part of the Constitution or not. So there are some key underlying concepts, and these concepts are enough to make you generally understand how things have to be executed. Now, let us look at the overall policy and the law and the procedure for territory. And let's go through it one by one. This is the law part, and this is the procedure part. As I've mentioned before, when we are categorically referring to law, Part 1 of the Constitution deals with territory. And part 1 comprises of Article 1, Article 2, Article 3 and Article 4. Article 1 and Article 4 are referenced to Schedule 1 because Schedule 1 contains a list of the names of the states and union territories and also contains a list of their areas. And because of a change in Schedule 1, there could be a consequential change or a correlational change to Schedule 4, which contains the number of Rajya Sabha seats to the center. Now, this is an outstanding application of rule number 2, center stronger than the states, wherein the constitution specifically mentions the number of Rajya Sabha seats to the center, making sure that there is a degree of legitimacy and mention in the supreme law of the country, which is the constitution itself. The irony, of course, is that the Lok Sabha will have certain overriding powers over the Rajya Sabha in some cases, and there is no concept of a political majority whatsoever in the Rajya Sabha. People can come from political parties, anti-defection law will apply, but there is no leader of majority or there is no need to establish political majority as far as the Rajya Sabha is concerned. Now, Article 1 effectively talks to you about 3 things. First, it says India, that is Bharat, which essentially identifies nomenclature for us. 2, it then says India is a union of states. This is reflective of rule number 2, the center stronger than the states. So this means that unlike the US, where British colonies came together in 1776, declared independence and said, we are now going to become the United States of America, it was actually quite the reverse. We were British India, we underwent through partition, then we became what is called independent India, we integrated princely states into India, and we've been on a consolidation exercise ever since. So it is truly reflective of our political reality that India is a union of states, which means effectively in India the union came before the states, in the US the states came before the union. It also is reflective of a very important part, that unlike the West or unlike many modern democracies, our sub-national units, our states, have absolutely no right whatsoever to want to leave India, to secede from India. There is no provision whatsoever in any form which allows the states to even initiate a procedure to want to leave India. Any territorial change is effectively at the helm of affairs of the parliament eventually, which is of course a central authority or a national authority, which is why it is often colloquially said in a lot of textbooks and judgments that India is an indestructible union of destructible states, while the US is a destructible union of indestructible states. Well, more on that later. So, the fact of union of states effectively represents what is called a national character, a unitary federal character. And it mentions what is the territory of India. This territory of India, as mentioned in Article 1, is going to be referenced in so many different parts. For example, when we look at part 3, there are going to be references to the territory of India. That territory of India is territory as per part 1. So therefore, the territory of India includes states, union territories, and anything that we may acquire in the future. Now, what does this mean? States and union territories is fairly sorted. What is not sorted is the larger discussion on what can you acquire in the future. Now, let me be very clear. The Constitution or any law in our country does not give the power to anyone to go acquire any territory. Because acquiring a territory would mean breaching somebody else's sovereignty. And it is a principle which is not particularly appreciated or liked in international law. So therefore what happens is we only look at the procedure. We only look at, you know what, you've acquired territory, we don't care how you've done that. Now that the territory is acquired, this is what we do to integrate the territory into India. So which basically means that we are effectively talking about the procedure of integration. We are not referring to the power of acquisition. I'll be very clear about this and repeat myself. We do not have the power to acquire any territory. It is a perverse idea under international law. What we do have are provisions that once the territory has been acquired, this is how we can make the territory a part of India. And therefore, taking cue from exactly this, you have Article 2, which refers to the procedure for acquisition of new territories. Article 3 refers to internal changes, which means if you are just reshuffling the territory, the area, the names of states or union territories. Article 4 is actually the background article. It is a star that says terms and conditions applied. Article 4 basically says if you're making any changes under Part 1, those changes will obviously happen to the first schedule. The first schedule is very much a part of the Constitution. Those changes will not be considered constitutional amendments under Article 368. Doesn't matter with or without ratification. So this means they've straight out put it across that it is requiring simple majority. This Article 4 is also reflective of rule number 2, center stronger than the states, which means you're not even dignifying a territorial change with any form of a heightened majority or a heightened status as far as the Constitution is concerned. So what happens over a period of time is there are certain territorial arrangements that are made, and because of those, the Supreme Court interprets certain provisions of Article 2 and creates certain exceptions to Article 4. Always remember, a Supreme Court or any court can interpret a law, can invalidate a law, can make a law operational or inoperational, but it cannot make any textual changes, even to a comma or a full stop, to any law. So the Supreme Court has interpreted Article 2 and therefore has provided for a special procedure given the nature of Article 2. Let's understand what the procedure is and let's understand why is the procedure. So, first things first, it very clearly identifies that a parliamentary law is going to be required. Article 2 is referring to external changes, while Article 3 is referring to internal changes. Now, what is interesting about external changes is that you are either bringing territory inside or you're sending territory outside. If you're sending territory outside, that would be a part of some state or union territory. If you're bringing territory from outside, it would effectively be added or subtracted to some state or union territory. So therefore, eventually the change is going to happen to the state or the union territory whose name and area is mentioned under Schedule 1. But what is remarkable about external changes is that external changes are essentially the byproduct of governmental negotiations. So generally what will happen is there will be a government executive order finalizing the negotiations that we may have had with another country, and that executive order will then have to be implemented through a parliamentary law. That's generally the process. But the Constitution generally just talks about this. This is just additional information. Don't have to worry about it as far as the prelims is concerned. So therefore, you require a parliamentary law. Now, it doesn't matter what kind of territory. If the territory is coming to India, you would require a simple majority. Because if it's coming to India, it's a good thing. It will add territory. Therefore, we have a positive notion to having more land. More land means more resources. More resources means the ability to provide for more people. So therefore, if any form of territory, does not matter what it is coming to India, you will require simple majority, as Article 4 would have had it. The problem is when you are giving away land, when you are giving away Indian land, which is a part of either a state or a union territory, to any other country. That's where a bifurcation is needed. The bifurcation is either it is disputed or undisputed. Now, why is this bifurcation important? It is important because if it is disputed territory, the union government anyways has the powers of foreign policy, so they're doing their job. But if it is undisputed territory, for absolutely no fault of the state or union territories, for absolutely no concern whatsoever, just out of sheer goodwill, if you'd like to call it that, you're giving away territory to another country. So therefore, you have two separate divisions. And because you have these two separate divisions, what will happen is the Supreme Court will give an intervention and will give an interpretation. And this interpretation comes from the in reference Berubari Union case of 1960. The Berubari Union case was a presidential reference which was made by the President to the Supreme Court under, I think, Article 143, and the Supreme Court was mandated to give a reply back because it was out of an agreement predating the Constitution. So the area of Berubari, if I remember correctly, was a part of the Jalpaiguri district of West Bengal, and there was some confusion over Berubari being a part of India but not shown on the official map, or Pakistan claiming it to be the other side, because back in the day Bangladesh was East Pakistan. So what was effectively decided is that on the basis of negotiations between the two countries, it was so decided that India will give Berubari Union to Pakistan. That's the basic idea. And if that is the basic idea, India very well had acknowledged Berubari Union to be a part of India. Berubari Union was not a disputed territory for us. We had absolutely no qualms whatsoever in claiming Berubari Union to us. So obviously the state of West Bengal was at a loss. So the Supreme Court then came in and said, you are effectively performing center stronger than the states. You are not giving away a disputed territory which you have the powers to adjudicate over. You're giving away territory which legitimately is yours. The least you can do is dignify it with a constitutional amendment under 368, but without state ratification. And without state ratification is the hollow candy. Because if it is concerning one state, I can't seek the permission of half of the whole number of states. And two, that would unnecessarily give a slight tilt of power to the states, and the ultimate idea is center stronger than the states. Now, in another case called the Maganbhai case of 1969, the Supreme Court gave an interpretation to if the territory is disputed. Now, if the territory is disputed, then you are simply doing your job. Through an executive order, you figured this out, and you are now simply going to pass it using simple majority as per Article 4. Because the Article 4 says any change which happens is not an amendment under 368, though it is amending Schedule 1. And if it's a constitutional amendment outside 368, we know we always require what is called a simple majority. Now, even in the case of an undisputed sort setup, you may have an executive order which would be prompting a constitutional change, but that's the background of it, and that's all right. Now comes Article 3, which are internal changes. Now, Article 3, which are internal changes, basically say that before you start adding or subtracting or reshuffling the areas or the boundaries or the names of the states or union territories, you will require a presidential recommendation, and you will fulfill it through a simple majority. It will amend Schedule 1 and you'll still call it a Reorganization Act. If it's a bunch of changes together, then the States Reorganization Act, like it happened in 1956. Or if it is a specific state, then maybe the Andhra Pradesh Reorganization Act, or maybe the J&K Reorganization Act, or even maybe say the UP Reorganization Act, and so on and so forth. Why the J&K Reorganization Act is a territorial change under Article 3 is because J&K was converted from a union territory which had special status to a union territory which was converted from a state which had special status to a state which had no special status. So that means you were a state like any other state. So if you were a state like any other state, then provisions for any other states would also apply to you. And that's effectively what happened when it comes to Article 3. They effectively used Article 3 and they converted the state of J&K into the union territory of J&K with a legislature, not functioning today though, and a union territory of Ladakh. So you've basically converted the state into two union territories, the first time in Indian history though. And Article 4 is, as I told you, the background article. So this is generally the law. Anything more than this I don't think is required as far as the prelims exam is concerned. Now let's quickly look at the external changes as we would know it to be. Now effectively what happens is there are two kinds of external changes. The special kind, as per Berubari Union's interpretation of the Supreme Court, is if you are giving away undisputed territory or literally anything else. Anything else would include, let's say you're getting disputed territory, or you're getting even undisputed territory. It absolutely does not matter. Or even if you are, let us say, giving away any form of territory which is effectively disputed in nature. So that's the important part. If territory is coming in, does not matter whether it is disputed or undisputed, absolutely requires the same majority. But if you're giving away territory which is undisputed, then you will have what is called a constitutional amendment under Article 368. So whether or not there's an executive order, a bill would be prepared, a draft constitutional amendment bill will be prepared. That bill would be changing Schedule 1. If needed, would also change Schedule 4 if needed. Now, interestingly, you will directly send it to the Lok Sabha and the Rajya Sabha, and then you would require the President to give an assent. Now, because it's a constitutional amendment, the President necessarily has to say, yes, there is absolutely no other option. Which brings me to a very important question. If you are giving away undisputed territory, does that necessarily lead to a reduction in the number of seats to the Rajya Sabha? Because it would have an impact on population. It may or it may not. The constitution is silent on it, so it is generally assumed that it is going to take what is called the passage which was required to pass the law in the first place. So this is how undisputed territories are legislatively, procedurally executed. Now, anything else is like any other law. Now, what generally happens is, very interestingly, is anything else you will simply require a bill. That bill has to be sent to what is called the Lok Sabha or the Rajya Sabha. They will pass it. It's a simple majority bill. Will go to the President. The President can say yes, the President can say no, and the President can also return. Now, in the case that there are internal changes, you will prepare a bill. Before the bill is placed before the Lok Sabha or the Rajya Sabha, you will require a presidential recommendation. This is nothing but a hollow candy to the states, because the President is elected by both the center and the states. And as a symbolic gesture, the President will refer it directly to the state legislature. Now, there is absolutely no time period given whatsoever. The President can assume consent. the reference is just symbolic. If the state does not respond in a specific time period, the matter ends there. And after this symbolic process is over, because anything that the state legislatures say is not binding on the president will therefore send it to the Lok Sabha or the Rajya Sabha. And when the president would send it to the Lok Sabha or the Rajya Sabha, they will again pass it using a simple majority, send it back to the president, and the president can say yes, can say no, or can return. As you know, there are never any time periods for the president to say either a yes or a no or even return. It's generally, this is how the process is done. So basically, any territorial change apart from giving away undisputed territory requires simple majority. That's the basic underlying factor. And because territorial changes are changes that are government driven, though it's not written anywhere, most territorial changes are government bills. Nowhere in the constitution does it say that a private member cannot introduce a territorial change. If they do, because a presidential recommendation is required, it will anyways go through the Council of Ministers, because the president under Article 74 acts on the aid and advice of the Council of Ministers. So this is generally how territory works. So what happened when we started out was, we were essentially a British colony. We were essentially British administered provinces or British administered regions. After the partition, we became independent India, and we started integrating what were called princely states. Now, from here, we have reorganized India. There are essentially the following phases. The first phase is generally from 1950s till about 1980s. Now, this is the phase where you generally see multiple reasons of reorganization, but the primary reorganization that will happen will be at a linguistic level. So basically what happens is, when we become independent, we've got part A, B, C, D states. There's nothing called a union territory. This is in 1950. In 1956, we become states and union territories. And 1956 onwards, we are reorganizing states and union territories as we think best. So part A were British provinces, part B were princely states, part C were special areas, and part D only had one state called Andaman. Yes. And in 1956, of course, Andaman becomes a union territory. So the first phase, from 50s till about 70s and 80s, is a linguistic domination reorganization. It also leads to the birth of regional parties. It also leads to anti-defection law rising up to unprecedented levels, which is why you would effectively have the 52nd Amendment of 1985 inserting the 10th schedule. Post the 80s, you will see a very heavy focus on reorganization of the northeastern states till about early 2000s. And from 2000s onwards, you will see a smaller state cut out from a parent state. They generally speak the same language, but there are developmental, welfare, or administrative reasons that actually take precedence. So whether it is a Uttarakhand or a Chhattisgarh or a Jharkhand, the parent states that they've been cut out from, or even Telangana for that matter, has been for developmental reasons, for welfare reasons, and so on and so forth. But as far as the prelims is concerned, I think this is more than enough, and we would not require anything more than this as far as the exam is concerned. Now, quickly moving on to citizenship, some basic dimensions and key concepts. So, we first understand, because the prelims question was on basic concepts of what is called single citizenship. So how we understood the dimensions of territory, we must understand the 4 basic terms which are associated with citizenship. Again, you can read the detailed handout if you'd like, but honestly this is more than enough. It's a very recent question that was asked. The chances of it being asked in Prelims 2024, to my mind, are negligible. So there is a concept called nationality. Now, there's something called a common law system, there's something called a continental law system. Now these are basically legal systems of the world that we've discussed in the first lecture, where you'll see differences of what is called the propensity of judicial review and the role of the parliament and so on and so forth. Basically the authority of the law versus the authority of the courts. In common law systems, the authority of the courts is slightly higher. In a continental system, the authority of the law or the parliament is slightly higher. Anyway, so nationality is a moral concept. It is a philosophical concept. It basically means where you originally come from, what your roots are, what do you identify as the country that you belong to. Now, in most countries like India, nationality and citizenship is often interchangeable, but there is a theoretical difference. Nationality can never be changed, but citizenship most certainly can be. Citizenship, if nationality is a legal concept, citizenship is dominantly a moral concept. Sorry, the other way around. If citizenship, if nationality is a moral concept, then citizenship is dominantly a legal concept. Now this means that you are a member of a sovereign state. It means you are an official member of an independent country, and because of the virtue of being a member, you are entitled to certain rights, certain functions, certain accesses to certain civil and political ecosystems, which non-citizens may not. So this is what part 2 of the Constitution deals with. A closely related concept to citizenship, and you would be playing an interrelated role, is something called domicile. Now domicile has two meanings: a national domicile or a regional or a state domicile. A regional or a state domicile does not find any mention in the Constitution. In fact, it is a welfare concept. But domicile, from a national point of view, is effectively where do you intend to stay permanently. This is where you come from, this is where you want to go. What do you call your permanent home? Where do you intend to stay for the rest of your life, or generally for a large period of your life? And the reason you have a concept of a national domicile is because if you want to be a member of a country, you would want to stay in that country for a long time. In any city, any state is okay, but you want to stay in that country, which is why national domicile and citizenship are correlational. You can't be given citizenship of a country if you don't intend to stay in the country for a long time, which is why India has a concept of a single citizenship and what is called a single domicile. Now, residence, on the other hand, is where you are currently staying. What is your current place of residence? It will also have an implication to citizenship, because whenever you're looking at mass migration, for example, India has had the unfortunate witnessing of the partition. So residency has been a very important requirement to figure out citizenship centric provisions. So you will often hear of the word ordinarily resident, OR. It's generally understood to be about 6 months. It's also used in several laws in several different contexts, but this is largely how it works. What we are primarily concerned with citizenship is citizenship and national domicile, and more importantly, citizenship. Now, when we look at the two basic differentiating factors, you're either a citizen or a non-citizen. Non-citizen, foreigner, alien mean the same thing. Now, this is a difference of political status. A citizen can vote, a citizen can contest elections, a citizen can hold public office, and a citizen enjoys all fundamental rights, enjoys all legal rights, no matter what. Of course, terms and conditions to legal rights will always exist, and so on and so forth. But a non-citizen will have limited fundamental rights, cannot vote, cannot contest elections in any manner, cannot even hold public office, no matter what the case might be. So therefore what ends up happening is the difference between a citizen and non-citizen is actually a political difference. Now if you take a magnifying glass and we try to figure out the types of citizens, you're largely looking at residents and non-residents. Now this is a geographical difference leading to economic implications. When we say resident, it again goes back to the concept of ordinarily resident. Do you largely spend your time in India? Around 6 months or so. You'll see this to be applicable to merchant navy people. If not, then you are a non-resident Indian. If you're a non-resident Indian, it is generally a financial implication. The Income Tax Act of India defines or gives you certain ideas of it, and non-resident Indians generally do not pay taxes in India. They will have lower property rights. They cannot even hold agricultural property under ordinary circumstances, because agriculture is a keen welfare sector for India, and if you're not majorly in India, then you're buying agricultural property for subletting purposes, and profit in agriculture is something that hasn't worked out. In fact, agricultural income is still today tax free. So therefore there is a larger way to understand the relationship between agriculture, tax and non-residency. Now when we look at non-citizens, now there are three kinds of non-citizens. You're either a legal migrant, which means you have a valid passport, you have a valid visa, valid travel documents, or you're a refugee. Now a refugee is somebody who has run away from their parent country because of fear of life, fear of property, fear of threat, and there is a 1951 UN convention on it, and India has not ratified that convention, which means India is under no obligation whatsoever to accept any refugee if we don't want to. And then there's something called an illegal migrant. An illegal migrant is effectively a criminal under law. You have illegally entered India without any travel documents. A related concept to this is internally displaced persons. They are generally those people who are moving from one part of the country to another part of the country because of some fear or threat in that part of the country. But refugees are effectively international transfers. Now, this is generally dimensions and key concepts. So this is how it works. Now, there is a differentiated mechanism. A legal migrant either comes from a friendly country or an enemy country. All countries that we don't get along with are not enemy countries. The government has to specifically identify an enemy country as an enemy country. So if you are coming from a country that we have identified as an enemy country, then you become an enemy alien or an enemy non-citizen, which means out of the limited fundamental rights that you have, you would further not have the right against the protection against preventive detention. So these are largely the dimensions and what are called key concepts. Now, having said that, there are very important citizenship centric points that you should know. A passport is a proof of Indian citizenship, absolutely, but not having a passport necessarily is not. Aadhaar is not a proof of Indian citizenship. A PAN card is not a proof of Indian citizenship. A voter ID is definitely a proof of Indian citizenship, because if you can vote, then you are, and only Indians can vote. So yes, you are an Indian citizen. Now, having said that, let's look at the policy and the law. The general understanding here is we've got in the Constitution Part 2, which deals with Articles 5 to 11, which are your primary constitutional provisions on citizenship. Article 11 is a very interesting article, and I'll tell you in just a minute. But the Constitution is also supported in the 7th schedule in the Union List, List 1, with entry 17, empowering the Parliament to make any law on citizenship. So the Parliament makes a law called the Citizenship Act of 1955. This act, of course, gets amended multiple number of times. The most recent amendment, the most widely known amendment, if not the most recent, has been 2019, and therefore it's called the Citizenship Amendment Act 2019. Now, what is remarkable about Article 11 is it's one of those rare provisions in the Constitution where Article 11 says if the Parliament makes any law on citizenship, that parliamentary law on citizenship will override constitutional provisions on citizenship, thereby giving a parliamentary law precedence over constitutional provisions. Now, this would generally not happen as far as the case is concerned. Now, this Citizenship Act becomes your current primary law to deal with provisions of citizenship. Apart from this, the nodal agency for citizenship is not the Ministry of External Affairs, it is in fact the Ministry of Home Affairs. Because if you want to apply for citizenship or your citizenship has to be taken back, then it is the MHA who does it, because you are going to be living in India. So you're going to be a part of the internality of India, and that has a law and order implication. So the MHA comes to task. Now, apart from the MHA, there are 3 executive bodies that have been set up. Now, the head executive body is the Bureau of Immigration. The Bureau of Immigration is the executive body set up under the MHA of sorts, and they are manning all immigration checkpoints. And under the Bureau of Immigration, at a regional level, maybe 2-3 states combined, you will have a foreigner regional registrations office, which will take care of any issues that foreigners are placing in that region or supervising immigration checkpoints for land, sea and air. And at the grassroots level, in case you don't have a dedicated BOI official, the district magistrates or the SPs can be foreigner registration officers. Now, if the basic principle is you have to be a legal migrant to be able to apply for citizenship, and you can apply for citizenship in 2 ways. 1, you can directly apply to the MHA, or 2, you can send an application to your nearest district magistrate. The right to citizenship has been recognized as a statutory right and a constitutional right as per the Arunachal versus NHRC case of the Supreme Court in 1996. So citizenship in that court's judgment is both a statutory right and a constitutional right, very much like property. So anyway, let's understand this from another perspective. So this becomes your law, this becomes your institutions. Now, citizenship is about the people in your country. So you need to count the number of people in your country. And for that you have something called the census. The census is a population enumeration exercise. It includes both citizens and non-citizens. It happens in multiple stages. So you can have a household stage, you can have an individual stage. The last time we had a census was in 2011. We were supposed to have one in 2021. It's a decadal exercise, but unfortunately we could not because of the pandemic. We are expecting the census to happen after the 2024 elections in a few months. And in 2011, an exercise called NPR, the National Population Register, was also conducted alongside the census. So what is the difference between census and NPR? Census is also citizens and non-citizens. NPR is also citizens and non-citizens. The difference is NPR looks at, are you staying in that area from an ordinary resident point of view? Are you ordinarily going to be residing in that area so that we can better target welfare schemes? What happened for the first time in 2011 was the fact that we had a biometric enumeration which was also taken. We had a digital enumeration exercise where the information or the collection was done digitally through a mobile device or an electronic gadget. So those have been some key ideas. The census, officially, there's a census division under the MHA, and the person who is the head of the census is the census commissioner. Now, technically the census is considered as an independent exercise, but the MHA has a census division which effectively takes care of any nodal formalities that may be required. Now, when we look at the provisions of the Constitution under Articles 5 to 11, Articles 5 to 8 deal with how do you become an Indian citizen. Articles 9 to 11 are about principles of citizenship. Now, let's understand what this is. Article 5, and again extremely irrelevant or extremely unlikely for the prelims exam. So let's just quickly run through this. Article 5 tells you how do you become an Indian citizen on 26 January 1950. So how do you become one? Remember, we spoke about domicile. What we are referring to is the domicile of India or independent India, because you're talking about as on 26 January, which is the commencement date. Now, the Constitution says commencement. It does not mention the date 26 January. But interpretation in the General Clauses Act refers to 26th January 1950. So, as per Article 5, as on 26th January 1950, how do you become a citizen of India? Number one, you've got to be a domicile in independent India, which means you've been wanting to stay in India and you call independent India your home. This is compulsory. Then one out of the two conditions should be applied to you. Either you or your parents should have been born in the territory of independent India. They were born in the territory which is independent, which means the territory may have existed pre-independence also, but even after post-independence, that territory remains to be a part of India. Basically, you should have been born not in Pakistan or Bangladesh. Now, either this applies to you or you have been ordinarily residing in India for 5 years prior to 26th January 1950. Either of these two conditions and you can become a citizen of India as on 26th January 1950. Now, if you look at Article 6 very clearly says, if you are migrating to India from Pakistan, what are the provisions that can help you? Either you or your parents or your grandparents, they should have been born in India as India was defined under the Government of India Act of 1935. You would remember in the previous lecture on legal history, I told you it was the Government of India Act of 1935, through its ambitions of an all India federation, that for the first time gave us the territorial idea of India. So you, parents or grandparents, should have been born in the Government of India Act defined territory of India. This is compulsory. If not, and beyond this, the two conditions apply. If you're migrating before July 1948, the exact date is 19 July, not important to be memorized for the prelims, or you're migrating after 19th July 1948. Now, if you're migrating before 19th July 1948, then you should have been ordinarily residing in post-independent India or independent India since the time you've migrated. Suppose you've migrated in 1949. Since 1949, you have been effectively living in India if you were a migrant from Pakistan to India. Now, that's the case if you've, this is pre-July 1948 or post-July 1948. So if you've migrated to India pre-July 1948, then you should have ordinarily been residing 5 years since 1950. But if you've migrated to India after July 1948, that's when an official agreement was signed between the two countries. post July 1948, then it has to be on a case by case basis. A special application has to be made by you, and on the basis of that special application, you would be granted citizenship by a government official if you have migrated after July 1948. But that application should have been made before 26th January 1950. That's the basic idea. Now, so pre-July 1948 or post-July 1948, the basic difference is pre-July you've ordinarily been residing for about since you've migrated, or post-July on a case-by-case basis, and that's the difference part. That's the differentiating part, which is pre-July 1948, you don't have to make an application. You have to just go through a process. But post-July 1948, you do have to make an application. This is Article 6. We move to Article 7. Article 7 deals with if you've migrated from India to Pakistan, didn't quite like it there, and now you're coming back to India. If that's the case, then no Indian citizenship will be granted to you if you have migrated to Pakistan after March 1947, unless a special permit has been issued to you and on a special case by case basis you have been allowed to come to India. So what about before 47? Then the prior provisions would apply as per Article 6 anyway. Now, Article 7. This takes care of the non-partition provisions. Article 7 is very interesting. Article 8 talks about if you are residing in any part of the world except Pakistan, which includes Pakistan and Bangladesh, you, your parents, your grandparents would have been born in India as per 1935, and very simply, you can go to the nearest embassy or the consulate and get yourself registered. Very simple, Article 8. Now, Articles 9, 10 and 11 largely speak about two things. We shall have a single citizenship. There shall only be a domicile of India. At a regional level also, you can only have a domicile of one state, but that's nothing to do with the constitution. And the parliament can make any law in continuation of this, and that parliamentary law will override the provisions of effectively Part 2, which contains citizenship. Now, the actual Citizenship Act, the final part of this. See, the Citizenship Act speaks to you about two things. One, how do you become an Indian citizen? And how can your citizenship be lost? It also reiterates the principle of single citizenship, and that's okay. At the most, what you need to know are current basic provisions without too much technical detail. There are 5 basic ways: birth, descent, registration, naturalization, and incorporation. So when we refer to birth, what do we refer to? A, you were born in India, and if you were born, and this is as of today, so the amendment happened in 2003, was in effect from December 2004. So basically, from December 2004, these are your birth provisions. A, you've got to be born in India. B, one of your parents has to be an Indian citizen. And C, the other cannot be an illegal migrant. This saw some ramifications because of the Citizenship Amendment Act of 2019, but that's not the relevant part as far as your prelims is concerned. This is it. As far as descent is concerned, you are born outside India, and when you were born, at the time that you were born, one of your parents is an Indian citizen. This has been the law since, if I remember correctly, 1992 onwards, and you have to compulsorily register yourself with the nearest Indian consulate and give up a citizenship if you already have of that country, and the process can be undertaken. Registration is a fairly detailed process. There are multiple conditions. For example, you could be a PIO, or a PIO residing in India for about 7 years. You could have married an Indian. Your parents could have been Indian. You could have been Indian. There are several cases. Please do not memorize this for the prelims exam. A PIO for the understanding of registration simply means a person or their parents who were born in undivided India or even in independent India, which means you would have, could have, should have become an Indian citizen if you could or if you wanted to. Naturalization is effectively discretion of the central government. There are provisions. Some of them are, for example, you've lived in India for about 11 years, or you've served the government, or you have a good character, you speak a language. It's a combination of factors. And lastly, what you have is incorporation. For example, when the land boundary agreement happened, we gave some enclaves to Bangladesh, we got some enclaves back. That would require an express grant of citizenship to the enclaves that we got. Incorporation, in a way, is an extension of naturalization to begin with, right? Now, as far as giving up citizenship is concerned, three things. One, you voluntarily have decided, I've got another citizenship, I want to say bye, renunciation. Two, the government found out that you were juggling two citizenships. So they said, please go, we don't want you to be an Indian citizen. That's termination. Three, you've lied on your citizenship application or some documents about you are untrue. So this is how you would lose Indian citizenship. If at all there has to be a question, I would definitely say there could be a question on certain basic factors or certain basic facts concerning the census, because the socio-economic caste census was actually in the news. And that's something that is too political to be asked in the prelims exam, but census could definitely be asked no matter what the case. So this is lecture number 4. Now I see you for the grand lecture, lecture number 5, which is the preamble, rights, duties and directive principles, along with sectoral reviews of the related issues. Thank you. Keep watching. See you in the next class.
Hello and welcome to the last lecture of topic number 1 of theme number 2, which is territory. And we're essentially going to be understanding an analytical version wherein we're going to be covering subtopic number 5 of topic number 1 of theme number 1, which is essentially territory. And the purpose of this lecture is to answer a fundamental question, which is, should India reorganize itself? Today, India is a collective of 28 states and 8 union territories, out of which 3 are union territories with legislatures and 5 are union territories without legislatures. And therefore, the India that we see today, is it the best organization of the people of India, wherein not only does it serve a governance advantage, an administrative advantage, but it is also collectively reflecting the aspirations of the people. So to understand whether India should be reorganized, we must get a little bit of a historical context into things. We must understand how does India become what it is. And the reorganization is largely an instrument of Article 3, which provides for the procedure of it, which provides for the process of it. And it essentially is done by the Parliament upon a presidential recommendation, which is being made after a reference which is being made to the concerned state legislatures. And the Parliament passes it through a simple majority. And even though it changes Schedule 1, Article 4 categorically prohibits it to be a constitutional amendment, and therefore it is not a constitutional amendment under Article 368. This is in fact a very clear application of rule number 2, wherein the Parliament, having the authority to make territorial changes to states, is an expression of center stronger than the states. The President recommending the bill to the parliament, and before the bill is actually sent to the parliament, the president taking a reference to state legislatures is the candy. And the fact that this is not binding in nature is what makes it a hollow candy or a hollow appeasement process. Therefore, territorial provisions are a very precise application of rule number 2 that we've studied as a part of the golden rules to our constitution in the earlier theme. And if the parliament is making multiple changes, it's usually called the State Reorganization Act. Now, we've had one such wholesale kind of an exercise in 1956 on the basis of the Faiz Ali Commission, which was appointed to do so. There were certain commissions before it. None of those commissions have to be remembered as far as your exam is concerned because they are historically outdated. But is it time for a new state reorganization commission? And do we need to rechange the country the way it is? There have been several intellectuals and academics in the country who've been saying that we are not uniformly assisting the way we should to reorganize, and there is a certain need, and we'll come to that. Post the State Reorganization Act, there have been several minor changes that have happened, and we'll come to that. But the context is that the British had sort of transferred power under the Government of India Act of 1947, or the Indian Independence Act of 1947, which was passed by the British Parliament, to the Constituent Assembly of India. And it is largely argued that the Constituent Assembly of India was dominated by the Indian National Congress. It was also around this year that the paramountcy of the British Crown over your native Indian states, or the authority of the British Crown, had also lapsed. And therefore, we were looking at a new reorganizational structure as well. But our concern as students of polity is to understand how we decided to do this and how reorganization of states was not just something which was a political consequence, but was also a major theme which was carried forward historically through our Indian national movement. So to understand this, we again look at our basics. We understand that India is in fact a union of states. So to give a little more introduction or a little more context to this is in 1947, India consisted of 571 princely states that were eventually merged to become 27 states. This was reorganized, sort of a makeover happened in 1956. So our first timeline is from 1947 to 1956. From 27 states to becoming what it is today is what we're going to understand. Now, in 1947, because we were becoming independent, and there were, of course, some bad dreams or some fears of the post-British Empire. This was largely done on the basis of historical and political sort of considerations. Now, around that time, we had several categorizations that were made. We had states which were formerly British Indian provinces. We had states which were formerly small native states, but did not really have a lot of problem joining the Indian Union. And third, they were essentially states which were not ready or were not very willing to integrate into India. And therefore, the rulers of those states wanted to exercise their options of independence. For example, J&K and Hyderabad, for that matter. Now, it was also widely understood that in 1947, it was a makeshift arrangement, and this was to be done only on a temporary basis. And we were essentially looking at historical or political considerations more than linguistic or cultural divisions. It's very important for us to understand that language or culture is a very strong determinant for a person's sense of belonging. a simpler analogy would be for those of you who went out of town to a different state for your higher education. The first set of friends that you made in college, if college was significantly away from home, were people who came from the same region as you or spoke the same language as you. Because culture and language are the easiest form of finding commonality, not only at a local level, but also a national and an international level. And therefore, linguistic and cultural aspirations have always been something which was an emotional sentiment for Indians. And especially post-independence, when we became independent, one of the implications of independence as expected by the Indian population was that we would want to call our area our own. And our area would largely mean people who speak the same language or have a similar culture, so to speak. But because we were dominantly multilingual and diversity has always been a necessary precondition to Indian society, if we compare the origins of India to the rest of the world, particularly the West, India has always had cultural, religious, sort of other forms of diversity very innately a part of society. And that is why we've been able to individually maintain the sanctity of, say, religious diversity. That is why we never say India is a melting pot of cultures, because India has always been a multicultural nation. That is not particularly accurate for, let us say, the United States of America. So therefore, it was understood that eventually we would have to reorganize the way we are, and we'll have to do it in a manner which is popularly agreed to by the people. But this noble gesture was going to face a lot of roadblocks during the way. This is the India of 1956. This is our first major reorganizational exercise. And if you see a lot of the India that you see in 1956, for example, the way Rajasthan is, the way Kutch is, Saurashtra is, the way Vindhya Pradesh is, the way the northeastern states are organized in 1956, to what India is today, are virtually unrecognizable. In fact, if we compare the territorial divisions that India has gone through, it would be correct to say that amongst all its peers in the world, the number of internal readjustments that India has gone to, or the number of internal changes that India has gone through, is amongst the highest when it's looked at with other parts of the world. And that is something to begin with. And that also reflects a sense of flexibility in the Constitution. It also reflects a sense of permission in the Constitution. The Constitution allows for these changes to happen in the first place. The Constitution isn't particularly rigid on those lines. So the fact that India has undergone the most number of internal changes than perhaps any other country in the world is therefore testament to an open-ended, or to a rather organic and a flexible constitution. And it is the study of these changes which therefore leads us to a larger discussion. And that is, have we really organized India the way it should be? Now, make no mistake, this is a very complicated question. Because on one hand, not only is this a legal question, it is also an ethical question. And you can actually use this as a brilliant example in your ethics answers as well. That it might make administrative sense to make a state a certain way, but it would be against the linguistic aspirations of the people. So if you have to make a choice between development and empowerment of the people, or recognition of the people, what would you choose? And these kind of ethical conflicts are essentially the reason as to why reorganization of states is what it is. Not only is it an administrative issue, it's a governance issue, it is a linguistic issue. There are several such issues that we battle with on a daily basis. So let's understand the prologue behind it. The context is, historically pre-independent India was divided on the basis of British conquered territories such as Bengal, princely legacies such as Jammu and Kashmir, and presidencies which were essentially heightened administratively autonomous units such as Madras and Bombay, which is why you will always notice that the high courts of Bombay and the high courts of Madras are in fact some of the oldest institutions in the country. And by the way, when we change the name of a city from Madras to Chennai, the High Court of Madras still remains the High Court of Madras. The High Court of Bombay remains the High Court of Bombay, not the High Court of Mumbai. It's because it is the center who has the powers to change the name of the high courts, whereas it is the states who get to decide what should they name the cities as. Similarly, IIT Bombay is still IIT Bombay, IIT Madras is still IIT Madras, because these are centrally owned institutions. So unless the central government wants to change their names, it doesn't matter what the states really want to do, because they're not owned by the states, or they're not under state control or administration of any kind. And this reorganization exercise also has a fair degree of historical context. The historical context for this reorganization exercise is that the formation of states, as we would understand it to be, was largely a historical and a political exercise. But in 1917, the Indian National Congress, which was your dominant organization, a political outfit, a freedom fighting party, which was fighting for India's independence, had committed to the creation of linguistic states. Not only was this a good idea, it also would resonate very strongly amongst the population and the masses, because you would have something to fight for. And to further the announcement that they made in 1917, in 1920, at the session in Nagpur of the Indian National Congress, they also started creating regional Congress units on the basis of dividing the country into linguistic zones. And that, therefore, it became an extremely important and a very, very strong message that could be sent out to the people of the country. Now, the leadership of the Indian National Congress, which would eventually also become the political leadership of independent India, because the Indian National Congress was dominantly occupying the Constituent Assembly as well, was in absolute support of the reorganization based on linguistic lines or on the lines of language. But the closer we come to independence, India witnesses perhaps one of the darkest moments in its history. And statistically, the partition of India into East Pakistan and West Pakistan, and today East Pakistan is Bangladesh, even till today, is the largest cross-border movement of human beings ever recorded in world history. And mind you, the world has seen the ostracization of the Jews by the Nazis. So to put it bluntly, there were more people who moved across the borders between India and Pakistan than Jews who fled Germany. And of course, the loss of life, occupations, property, livelihoods is unquestionably too high to even pay attention to, or to quantify. And this partition of India had a significant impact on the thinking of the political leadership. They generally thought that if India would fight itself and people would slit each other's throats because of religion, it could be language tomorrow. And society in India is not stable enough today, because if you decide to bifurcate on linguistic lines, one element is absolutely for sure, that everybody is not going to be happy. There are a few communities who will continue to be marginalized. There will be few communities who will continue to serve as minority communities. But at the same time, you will not be able to please anyone. That is the case with any government policy for that matter. You can't please everyone. So therefore, Jawaharlal Nehru strongly did not want to pursue the idea of a linguistic redivision of the country. It was of course supported by Sardar Patel and Rajaji. And they eventually convinced Gandhiji to also propagate that it was a wise idea to postpone reorganization in the country. Now, we must remember that the general elections happened in 1952, and the first Lok Sabha also happened in 1952. So from 1947 till 1952, the Constituent Assembly also functioned as the interim parliament. And of course, Jawaharlal Nehru was not only India's first prime minister, was also India's first interim or the only interim prime minister to facilitate the transfer of power. Now, while we decided to postpone it in 1947, the people were anxious. So from 1947, in fact, from 1946 late end itself, the Constituent Assembly decided to form commissions, committees of people who could examine more academically, with a lot more insight and research on what is the best mechanism to reorganize the states or the federal units in the country. And therefore, a rationale had to be divided. Now, it would be incorrect to say that India is divided only on the grounds of language. While language is a fairly major theme, but it is not the only reason why states have become what they are. States like Andhra Pradesh and Orissa dominantly are because of linguistic reasons, no doubt. But there are also states in the northeastern part of the world which are culturally extremely different from each other. May not necessarily be the case with language. So Mizoram, Manipur, Tripura. We've also seen instances where a specific state was carved out on the basis of a religious majority called the state of Punjab. Most recently, we've seen the bifurcation of Telangana from Andhra Pradesh, which was largely done for reasons of better governance and administration than language or any other reason. We've also seen the recent conversion of the state of J&K into two union territories of J&K and Ladakh. And the primary reason cited by the government was security and better welfare. We've also seen states of Uttarakhand, which were not ethnically very different from Uttar Pradesh, but no doubt was extremely backward when we compare development in UP versus development in Uttarakhand, largely because of the geographical factors of Uttarakhand. Also, the smaller creation of states, more specifically Jharkhand and Chhattisgarh. The reason they were made as they were largely because these newer states had more resources than their parent states. But despite having more resources, they were significantly underdeveloped and with the tribal intake in those areas. And of course, we've also had colonial factors of creating a certain set of states, such as Pondicherry, a certain set of states such as Goa, and of course, a union territory called Pondicherry. So the point of this exercise is to tell you that at no point of time was language the only criteria, right? Today, of course, we see a lot of sub-state movements that are happening across the country. And these movements have largely started from the 1980s. For example, you would have heard of the Gurkha National Liberation Front in the Darjeeling Hill district of West Bengal, or the Bodoland agitation in Assam, or for that matter, the Chota Nagpur region in Bihar. You will see that a lot of these regional development councils were set up, but these regional development councils were not able to give them the kind of recognition and the kind of autonomy that they wanted as a federal unit. Not only this, we've also were most popularly seen the case of Delhi, which has been asking for a full statehood. Now, in territory, it will not be wise to understand the power arrangement of issues such as Delhi or the Northeast or certain special states, because this isn't as much about territory as much as it is about center-state relations. So when we study federalism in our upcoming themes, we will understand these as special cases and how can we make them better than what their current state of affairs is. Now, historically speaking, there were essentially three commissions that were set up, and the recommendations of the final commission were accepted by the government with certain modifications. The first was the Justice Dhar Commission, or the First Linguistic Reorganization Commission. The second was the JVP Commission. The third was the Faiz Ali Commission. And I'll tell you a little bit about it, but please do not memorize this for the prelims, nor do you need to memorize it for the mains. You just need to know that in one line, what was their thematic reason or what was their rationale of recommending reorganization. Even if you know just Faiz Ali, it's more than enough. Even if you don't know the first two, it's completely okay. As long as you know that these names have something to do with linguistic reorganization or reorganization, that's more than enough. So the first commission was called the Dhar Commission, was set up by the Constituent Assembly or the interim parliament under the leadership, of course, of Dr. Rajendra Prasad, was headed by Justice S.K. Dhar. And this committee was extremely pragmatic, extremely practical, and singularly, it rejected the idea of a linguistic basis. It said that it is not going to help us in developing the country the way we want to, and therefore recommended more geographical, financial, administrative, or development-centric reasons for reorganization. So they said linguistic is off. What we should be looking at are administrative or financial or any such forms of reasons with the way we should be conducting our reorganization. Now, this was particularly taken very poorly by the Indian population. We felt betrayed, we felt cheated, we felt as if this is not what we signed up for. While it may not make administrative sense, but sometimes it is the needs of the people that have to be given a lot more primacy than just administrative factors. And as a result of this, severe protests started erupting in parts of the country, dominantly the South, because they were fighting for more linguistic clarity. And as a result of this, the best way to solve issues with respect to a committee is unfortunately to set up another committee. And that's exactly what was done by the government. And they set up the second reorganization commission, which was the JVP committee. It comprised of Jawaharlal Nehru, Vallabhbhai Patel, and Patabi Sitramaiah. This was set up in 1948 to study the recommendations of the Dhar Commission. It also very blatantly and categorically, and you could see this coming, that these are the people who appointed the Dhar Commission in the first place. And therefore, if these are the people who appointed the Dhar Commission in the first place, it's very likely that they will also echo the same sentiment. And therefore, they also rejected a linguistic factor. They said we should be looking at national integration or economic feasibility and so on and so forth. And therefore, they also largely provided the same rationale as the previous Dhar Commission did. This again was taken extremely differently by the population. And a gentleman by the name of Potti Sriramalu, who was a very, very well-known social activist and freedom fighter, was the OG Anna Hazare, if you would call it that, took a hunger strike unto death and died while being on hunger strike. And therefore, the government had to give in to the demands. And the first state to be created on linguistic grounds, therefore, happened to be Andhra Pradesh. And once this happened to Andhra Pradesh, it was essentially a trickle-down effect. And therefore, the government appointed the Fazal Ali Commission. And the Fazal Ali Commission was a balancing act. It tried to make it the best of both worlds and said that no doubt you should have linguistic and cultural reasons. We should also have reasons of security, economic, and development. So it tried to balance both of these. So even if you just remember that the first two commissions were anti-linguistic and pro-security and development, whereas the Fazal Ali Commission was balancing both of these, that's good enough. And as a result of this, the Fazal Ali Commission recommended that from the original 27 states, India should become 16 states and 3 centrally administered regions. Now, centrally administered regions means you're a midpoint between a state and a union territory, between a state and the center. So this is the center, this is the states, this is a union territory or a centrally administered region. So for example, in the context of China, Hong Kong and Macau are actually called centrally administered regions of the People's Republic of China. They have been given certain autonomy, but they will have to listen to China for a large number of things. So what happens is a union territory is closer to the center in terms of its powers than the autonomy of the state. So a centrally administered region is somewhere between a central territory and a state territory. So this was recommended, but the government said we're not going to call it a centrally administered region. In fact, we're going to call it union territories. So we therefore finally had 14 states and 6 union territories as per the recommendations of the Fazal Ali Commission, which the government accepted, and therefore the State Reorganization Act of 1956 was passed, which also led to changing Schedule 1, and this was largely created. And this is the larger ecosystem. And ever since, we've seen, for example, Himachal Pradesh become a state. The name of this was changed to Lakshadweep. Manipur and Tripura became a state. We created new union territories. Pondicherry is a union territory. Goa became a state, and so on and so forth. But the only movement from a state to a union territory is with the case of Jammu and Kashmir, right? And then we've seen a series of reorganization acts starting from the 60s. We've seen the Bombay Reorganization Act, Kerala, Nagaland, Haryana, Mysore. We've seen Himachal Pradesh, the first union territory to be made a state. We've then seen the Northeastern Reorganization, which created Manipur and Tripura, and so on and so forth. And the most recent ones are, of course, for example, with UP, it was first UP and Uttaranchal, and then we renamed it from Uttaranchal to Uttarakhand, which will also require a reorganization act, because renaming is also a function of Article 3, which is not a constitutional amendment under Article 368. More recently, we've seen Jharkhand, Telangana, and the Union Territory of J&K, which was created very recently in 2019. So this is the context. Now, in the UPSC, you would be asked a very simple question around it. Should this happen or shouldn't it happen? For this, I have a simple one-page model answer for you. Remember, whenever you're writing an answer in polity, The introduction of your answer has a checklist. You can use any of the following things that apply to the question. The first is a definition. The second is a data. The third is a legal provision. The fourth is an international document. Or the fifth is any contemporary development. Now, if the question is, should India reorganize itself? When we look at the introduction checklist, contemporary developments will have a degree of gravitas, and that's exactly what we've done. Recently, the chairperson of the PM Economic Advisory Council, Vivek Devroy, had spoken about the need of a second state reorganization commission as an agenda for further reform. And as discussed before, there have been several statehood demands that have been making the news. So the probable question is, should this happen or not? Now, this is our introduction. A simple body can be made. Now, there are multiple ways about going through this. So the first way to write a polity answer is a subdivision method, where you simply divide the question into smaller questions, or you follow the W method, the what, where, when, how method, or you simply write advantages, disadvantages, and conclusion. These are equally effective answers. There's nothing to worry about it. So a positive, negative, conclusion. There are also thematic ways of going about it. There are standard themes that can be made. So for example, in a reorganization question, why would you want to reorganize? Or why would you want to make smaller states out of bigger states or reorganize them? From an administrative point of view, from a welfare point of view, and from a representative point of view. Now, these become your themes for the main body. Then you can write from an administrative point, smaller states make sense, so we need to redivide it. From a welfare point of view, smaller states make sense, so bigger states make sense. Or from a representative point of view, smaller or the bigger states make sense. Always remember, the advantages of smaller states will always be the disadvantages of bigger states, and so on and so forth. So bigger states will have more representation to the center, will have more finances, and therefore will have more political clout. Smaller states will be more representative, the development will be more focused, you will have precise infrastructural upgrades, but you may not have a lot of finances, you'll be dependent on the center. Now, the State Reorganization Commission, as we understand, this becomes your historical context, was set up by Faiz Ali, and these were the larger reasons as to why it was done. The four factors were, of course, security, linguistic homogeneity, planning and promotion, fiscal and economic. So this can be made as a small diagram. Now, constitutionally, we've also given some legal points around it. So Article 3 essentially provides for reorganization of states. You can also mention that such a reorganization does not become a constitutional amendment under Article 368. Now, why are people wanting separate states or newer states? Linguistic and cultural reasons. For example, post-independent states such as Kerala, Tamil Nadu, Karnataka, Madhya Pradesh, etc. were given that kind of a status. So why not have further such divisions? Second, there is a perceived negligence by the political executive. These are all formed, all the three states that were formed in 2000 were much richer in natural resources than their parent ones. And therefore, there has been a sense of neglect or a political apathy by the mother states. Third, unbalanced or unequal growth has, of course, led to a lot of intrastate diversity. For example, East UP and West UP are two different worlds altogether. And of course, from a cultural point of view, from a regional point of view, there are actually identity differentiations such as Bodoland and so on and so forth. So this larger issue of should India reorganize itself, this exactly has two questions. Either you would be asked, should India reorganize itself? Or you would be asked a question on big versus small states. Now, this has already been asked in the exam. Do big versus small states from a governance point of view? Therefore, if at all there has to be a question, it would be from a federal point of view, which we will cover in our theme on federalism. And there are, if at all, there could be a question on reorganization. So this becomes our main body. And after the main body, we can now look at the rationale behind. So why do we need it? Apart from that is, of course, the reasons for liberalization and all of those. But there could be a need for the second reorganization state commission, because this would essentially help in faster growth. It could end the politics of cultural identity. It could lead to better governance. It could also try and solve internal security reasons. It could also have better interstate relations and relations between the center and the states. The problems are, of course, money is an issue. Second is you do it for one, everybody else will want it. The third is just because you have a smaller state, it does not necessarily mean that there will be better development. And of course, there have been a lot of critics who said that just because, again, you have smaller states, there's no absolute guarantee that they will be governed better. So therefore, the conclusion is, of course, always the middle path. The conclusion for the middle path is the creation of a federation consisting of smaller states is a complex task and will require very careful attention. And therefore, when the time comes for reorganizing it, we should do it by balancing all possible factors. So whether you get a question on reorganization or you get a question on governance, this is the answer. You will not be asked anything beyond this from topic number 1, territory, in your prelims or your mains. I will, of course, attach this model answer also so that you can revise it further or you can make it better, and we'll do that eventually in a consolidated note as well. So this covers topic number 1, and we are now done with it in the right amount of detail. Thank you. Hello and welcome to lecture number 7 of theme number 2, territory and citizenship. And we're on topic number 2, which is citizenship. And the case study of this lecture is dedicated to the Citizenship Amendment Act of 2019. And the Citizenship Amendment Act has been in the news recently, largely because it has been challenged in the Supreme Court as well. Now, at the very outset, it is extremely unlikely for a question from here to come in the prelims, but we shall prepare nonetheless. And it is also equally unlikely to get a dedicated question on the analysis of CAA in the mains. But the Citizenship Amendment Act of 2019 will definitely serve some academic relevance as far as the syllabus is concerned. So why does the Citizenship Amendment Act of 2019 become important as far as the UPSC syllabus is concerned? Number one, it is a rights issue. And the rights issue is in your prelims and your main syllabus both. So you may be using it or referencing it to say questions with respect to fundamental rights in the pre and the mains. Second, it also has a federal impact and therefore could be looked at it from the lens of federalism as well. Number three, some contextual events because of which the CAA becomes even more sensitive have implications on internal security, which of course is again an element of your main syllabus. Fourth, it also is a larger policy question on migrant populations and the responsibility of the government to take care, empower, and emancipate migrant populations. And fifth, this is also a fantastic case study or an ethical dilemma to repeatedly use across paper for ethics, integrity, and aptitude. So, to my mind, these are the 5 major use cases or the 5 major areas why the Citizenship Amendment Act of 2019 sort of becomes important. Now, with that in mind, let us spend some time on understanding the Citizenship Amendment Act. See, when we study the Citizenship Amendment Act, we must understand that there is going to be a conclusion that we're going to be arriving at. And whenever we identify the conclusion at the beginning, we begin with a hypothesis. A hypothesis is an assumption of the result of our understanding that will happen in the future. The hypotheses are, number one, the CAA 2019 in itself could be controversial, definitely has some problems around it, or it is an issue of legal expertise. It could be a problem. But the larger problem is when the Citizenship Amendment Act of 2019 is applied in conjunction to the implementation of the National Registrar of Citizens, which makes it even more sensitive and a larger problem, a more complex problem to worry about. So therefore, our primary hypothesis when we study the Citizenship Amendment Act is the fact that in itself, it could be, say, a problem to a limited degree, but when it is implemented together with the National Register of Citizens, that is a larger problem area to concern ourselves with. And towards the end of our discussion, we will come back to this hypothesis itself and figure out whether this continues to stand true or not. Now, with that in mind, let us understand certain basic concepts or certain background concepts. So there are a few background concepts that we must know. The first background concept is that it is called the Citizenship Amendment Act of 2019. Now, this means that it is going to be amending the provisions of the Citizenship Act of 1955, which has been amended multiple number of times in the past as well, in 87, in 2003, and so on and so forth. But the more controversial and the more in news is the Citizenship Amendment Act of 2019, particularly with respect to certain amendments that it has been making. So that's the first part. The second part is a simple conceptual principle that we have studied in our earlier lectures as well. And that is that you have to be a legal migrant to be eligible to apply for citizenship. This means illegal migrants are not eligible for citizenship. In fact, illegal migrants face criminal action as per existing Indian laws. So therefore, illegal migrants have to first become legal migrants, and only then will they be eligible for citizenship. Otherwise, they will not be. So this is something that we must understand under all circumstances. That is, that only and only legal migrants are eligible it is only and only legal migrants who are considered to be absolutely legible to obtain Indian citizenship. So that's the second provision. And that's the second background concept, which is important. Now, these are the two foundational concepts on the basis of which everything else is built upon. So now let us understand all of this in a fair amount of detail. So as we understand that the Citizenship Amendment Act of 2019 has amended the Citizenship the Citizenship Act of 2015, right? Now the basic question is, what has it amended? The primary question is, what has been changed? Let's understand this. There are essentially two things that have been changed. First is the definition of illegal migrants, and second, certain provisions with respect to naturalization. Certain provisions with respect to naturalization. Now, these are the two primary changes which are essentially of dispute. Now, apart from this, there is also a third change, but that third change is absolutely of no relevance. It makes no difference to the debate. The third change is essentially about grounds with respect to the cancellation of OCI cards. Now, there's absolutely no objection which has been raised to this specific issue. The problems are fundamentally with these two things. First, the definition of illegal migrants, and second is the process of naturalization which has been changed. So now that we understand it, let us get a far clearer picture and understand what are these changes that we are talking about to the amendment. Now, we're talking about the first change, which is the definition of illegal migrants. So let us understand what is the original definition and what is the new definition. So the original definition is something fairly simple. The original definition is that as per the Citizenship Act of 1955, an illegal migrant is a foreigner, right? An illegal migrant obviously is a foreigner who fulfills one out of the two conditions. The first is a person enters India without valid travel documents. Now, these valid travel documents are a combination of a passport or a visa. So either it is a fake passport or an expired passport, or it is a fake visa or an expired visa, either of the two, or there is no visa at all. So these are your two travel documents which are essential. If you are traveling to India, if you're coming to India without either of the two, then by Indian law, you are an illegal migrant. And the second is, if you've come to India on a visa, the visa was for, let us say, 6 months, but you have overstayed your welcome in India. If you stayed beyond the permitted time, then also you become an illegal migrant, because visas are given in most cases for a specific time. You would remember in the case of an overseas citizen of India, the visa is given for a lifelong period with multiple entries. But visas are usually given for a definite period, for a definite purpose, with a definite amount of entry and exit to and from India. So the second condition is, if somebody is staying in India beyond the permitted time. Now, this is the original definition. What happens now is, this original definition gets changed. Now we have a new definition. The new definition, very simply put, is an exemption definition. It basically says everybody is an illegal migrant except the following. So it basically says, it adds a certain criteria, it adds an exception to the current definition. It adds an exception to the current definition. So the question is, what is the definition? What is the exemption that has been added? It identifies 6 communities. It says, if a person is a Hindu, or let us say a person is a Sikh, or if let us say a person is a Buddhist, or let us say a person is a Jain, or let us say a person is a Parsi, or let us say a person is a Christian. If you are from either of these religions and you are from the ABP nations, which are Afghanistan, Bangladesh, and Pakistan. Afghanistan, Bangladesh, and Pakistan. And you have entered India on or before 31st December 2014. On or before 31st December 2014. In that scenario, you will not be an illegal migrant. You will become a legal migrant. You will be a legal migrant. That's the basic provision. Now, it is important for you to understand the Act does not say non-Muslims. The Act says and identifies 6 communities from 3 countries who've entered India before 2014. And if they are illegal migrants, they will become legal migrants. If you're already a legal migrant, then there is nothing to worry about. But if you are an illegal migrant, from now onwards, you will no longer be an illegal migrant, you will become a legal migrant. And any pending criminal action against you will be withdrawn. You don't have to worry about the force of the law, the power of the law. It's that simple. Now, for simplification purposes, we can say that non-Muslims coming to India from ABP countries till 2014 are no longer illegal migrants. This becomes our primary sort of a conclusion. So we can say this just for simplistic purposes that non-Muslims from ABP countries entering India will now be entering India who were illegal migrants will now be legal migrants. Okay. This is the fundamental primary change that has happened. This is your change number 1. Change number A. Now, there is change number B. Okay, this is the first change. Now, the second change is with respect to your naturalization provisions. Okay, the second change is with respect to naturalization provisions. The second change is that acquisition of citizenship by naturalization, which is one of the ways to acquire Indian citizenship. Now, the original text of the Act said very clearly, very simply said, that you should have been living in India for about 11, 12 years before applying for citizenship, then 12 years. So the entire process was long enough. So your first provision was that you should have been living in India for at least 11 years before applying for citizenship through naturalization. Simple provision. But the new provision is again creating an exception. It again adds an exception. It says for everybody else, the provision applies. But for these special people, but for non-Muslims from ABP countries who've entered India now are legal migrants, because the first change is allowing them to be legal migrants who've entered India before 2014. They don't need to wait 11 years. They only have to wait for 5 years. As long as they have stayed in India for 5 years, they are eligible for citizenship under naturalization. For everybody else, you will have to spend 11 years in the country. Okay, it's that simple. So this is the change. Now this becomes your second change. Now let us add both of these changes, right? So we have certain case scenarios. Our case scenarios are, for example, let us say there is a Hindu from Afghanistan who illegally entered India in the year 2000. What happens to this person? First, this person becomes a legal migrant. And now this person will not require 11 years of stay in India, just 5 years of stay in India. Okay, simple. Let's take another case. For example, let us say that there is a, let's say there is a Sikh from, let us say, Pakistan, who legally entered India in the year 2014, is already a legal migrant. He would have ordinarily needed to wait 11 years, but now in 5 years itself, in 2019 itself, the person can apply for Indian citizenship. Okay. Now let us take some adverse case scenarios. Let us take some difficult case scenarios. Let us say there is a Buddhist from, let us say, Bangladesh, who illegally entered India in 2017. This person will continue to be an illegal migrant because your cutoff date is 2014. And this person will still be considered a criminal as per Indian law, right? So that's important. Let's take a fourth scenario. Let us say this person is a Muslim who has come from Afghanistan has legally entered India in the year 2014. The person is still a legal migrant, but will the person have to wait 11 years to apply for citizenship under naturalization? Clear? So these are some of the variables that apply. Let's take a final case scenario. Let us say there is a person who is a Christian who is coming from Pakistan, who has, let us say, legally entered India in 2018. This person is still a legal migrant, but will have to wait 11 years because the person came in 2018, not before 2014. So these are some of the basic scenarios. Now, while all of this is happening, the larger question is why? The Indian government says that non-Muslims are a religious minority across Afghanistan, Bangladesh, and Pakistan, and they have been historically persecuted or exploited or disadvantaged or discriminated against. And therefore, it is India's moral responsibility to give them a space that they can call their home and feel safe in. This is the primary rationale that has been given. The fundamental problem that the opponents of this have with is that you are creating a group of people, or you are classifying this on the basis of religion, and the purpose with which you are doing so is not justified. And therefore, you are violating Article 14, the right to equality, which is a right which is available not only to citizens, but also foreigners as well. So we'll come to that. We'll come to the analysis in a while. So this is the general application. What you also must understand here is that these provisions as we know them to be, are to be applied to the entire territory of India, except two areas, or except two places. One, they will not be applicable to the tribal areas which are mentioned in the 6th schedule pertaining to the states of Assam, Tripura, Mizoram, and Meghalaya. There are specific sort of districts such as the Karbi Anglong in Assam, the Garo Hills in Meghalaya, the Chakma district in Mizoram, and the Tripura tribal areas district. The second is, there is an old British demarcation called the Inner Line Permit System, right? It's called the Inner Line Permit System, wherein you require a local permit to go to some of the territories or to go to these states, such as Arunachal Pradesh, Mizoram, Nagaland, for example. This Inner Line Permit System is governed by the British East Frontier Regulation of 1873. And here also, these provisions will not be applicable. The reason is that these are indigenous areas where the interests of the local populations have to be protected, and they cannot be adversely put to an objection. This part later creates a federal issue as to why that has been done and were their views taken on it or were their consent taken on it. This is largely what it is. And a very small point, which is once their citizenship is being done. So the idea is you are now a legal migrant. You can apply for citizenship under naturalization, and the citizenship will be given to you from your date of entry. Your citizenship shall be given to you from your date of entry. You could have come at any given point of time, and from that time, even if you had come in the year 1980, you will be a citizen of India since 1980. These are your provisions. This is the Citizenship Amendment Act in a nutshell. There is nothing more and there's nothing beyond this. Now, as I told you, the primary objections with this are the way groups have been made, the way these classifications have been made, which seems to largely be a problem of Article 14, which is right to equality. Now we come back to our original hypothesis, which is the Citizenship Amendment Act is certainly a problem, but the larger problem is with the Citizenship Amendment Act and the National Register of Citizens. Now, to understand this, we will have to first understand what is the National Register of Citizens, where does it come from, and what is the reasons behind it. So let's get this right. Okay. So the facts are the facts. As the name suggests, NRC stands for the National Register of Citizens. Okay. As the name suggests, the National Register of Citizens is an official record of the citizens of India. It's an official record of the citizens of India. Now, historically, there have been only 2 NRCs that have been conducted in India's history. 2 NRCs which have been conducted in India's history. The first NRC was an all India NRC. This all India NRC was conducted after 1951, which was the first official census of India. The first official census of India. Okay. Now, the second NRC, this is where things get slightly problematic. The second NRC was only conducted for the state of Assam. Now you had to identify basically who's a citizen and who is not a citizen in Assam. This was done as per Supreme Court directions. The Supreme Court had ordered for it. It took about 5 years and it costed about 1,200 plus crores. And all residents of Assam, everybody who was living in Assam, they had to prove that they were they were a citizen of India, right? Now let us figure out how could they figure this out, okay? This NRC list was coincidentally released in 2019 itself, the same year the Citizenship Amendment Act was passed. So sometimes coincidences can be slightly problematic. Now, what happened is something which is what we have to figure out. So the basic explanation is this: you had to update the NRC for Assam. The last time it happened for India and Assam was in 1951. Now let us figure out why and how could you do this. So if you were somebody who was living in Assam, a government official would come to you and ask you to prove that you are an Indian citizen as of today, because the NRC was being updated. Now, for that, and this is where it gets a little bit of contextual in nature, there were two options. Option number one, that your name should have existed in the legacy data. Legacy data is old data. Now, what is the legacy data here? The old data is A, your name should have been in the original NRC that was conducted in 1951, and your name should have also been in the electoral rolls of Assam till the midnight of 24th March 1971. 24th of March 1971. Now, why is this important? It's because 24th of March 1971 is also around the time Bangladesh was liberated. And in that entire process, East Pakistan, which was previously called Bangladesh, was witnessing a lot of hostility on ground. As a result of which, there was a massive movement of people, illegal migrants specifically, from Bangladesh. And the borders with Bengal were slightly marshy, but the borders with Assam were slightly accessible. And therefore, there was a massive movement of illegal migrants from Bangladesh to Assam. And as a result of which, it started causing local resentments in Assam. And these local resentments became a growing cause of concern, because this caused a lot of problems in Assam. There was an issue of an identity crisis. There was an issue of an environmental degradation. It was very difficult to identify illegal migrants. Most of these illegal migrants from Bangladesh to Assam were largely Muslims, so there was a community clash. There were also an increased financial burden on the government because illegal immigration had happened and the government had to provide for welfare. And these people who had migrated from Bangladesh to Assam came from the poorest of the poorest sections of society and were willing to work at lower wages than the local Assamese population, thereby displacing the native sort of workers. And as a result of which, there was a political agitation. Small terror outfits also started to come up, which later becomes an issue of internal security. It also was a massive issue of illegal voters because you could procure government documents rather easily. So as a result of this, the petitions were filed in the Supreme Court back in the day. And the Supreme Court in 2013 ordered for the NRC to happen in Assam so that you could identify who's a migrant and who's a citizen, so that schemes could be better identified, beneficiaries could be identified, and so on and so forth. So as a result of which, a massive exercise had to be conducted. About 33 million people in Assam had to prove whether they were Indian citizens. So one of the ways was either your name was in the original NRC of 1951 and you were an Assamese voter before the liberation of Bangladesh on 24th March 1971, or you were related to somebody who was who had their name in the legacy data. Either one or two, related to somebody whose name was in the legacy data. Now, obviously, these are also the poorest of the poorest sections of society. And as a result, they also may not have the necessary documents for it, which also created a lot of local resentment, which was also echoed by several interest groups, NGOs, and outfits in the country. So when in 2019, the updated NRC list for Assam was released, there were about 19 lakh people whose names were left out in the updated NRC list. So these 19 lakh people were now suddenly illegal migrants. These 19 lakh people were suddenly illegal migrants, and therefore they had to be sent to detention centers where, of course, there were issues of hygiene and sanitation and general upkeep and cleanliness. And the whole process of reevaluating your name or cross-checking or appealing the decision was a very, very long one. And dedicated tribunals were also set up. A foreigners tribunal was also set up where you could question this decision, because at the end of the day, it was a quasi-judicial decision. So this is the entire process. Now comes the complex part. This is your NRC. Now, we've understood that because of the NRC in Assam, 19 lakh people were now suddenly illegal migrants. And most of these people who were considered to be illegal migrants, a large majority were from Bangladesh and also followed the religion of Islam and therefore were Muslims. And this has been conducted in 2019. Now, let us apply the Citizenship Amendment Act provisions of 2019 to the NRC result of 2019. We have a bunch of illegal migrants from Bangladesh who have largely come around the 70s and 80s. Yes, this is our problem statement. Now, out of these illegal migrants, non-Muslims, they come from Bangladesh they've entered India before 2014, even if they're illegal migrants, will now become legal migrants because of the Citizenship Act of 2019. And they've been living in India for decades. They've already completed their 6-year tenure, and they will be given citizenship by naturalization. But the Muslims from Bangladesh who came to India before 2014 will continue to be illegal migrants because of the Citizenship Act of 2019. So that is why the Citizenship Act and NRC also adds a religious undertone and a religious implication to the entire ecosystem, right? So this is why, and this is the basic principle around it. Now, there are some fundamental questions that must be understood. That the National Register for Citizens is itself a flawed process, because you would require officials of the Election Commission, foreign tribunals, the Assam Border Police to work together. And there were several instances of non-coordination. So that's the first reason. The second reason is that now these are illegal immigrants. These illegal immigrants have to now be deported back to where they came from, which is Bangladesh. But we do not have any formal agreement with Bangladesh to send them back. This would lead to our diplomatic relations with Bangladesh to be in a state of jeopardy, as a result of which the future of those people whose names have not been included or have been left out in the updated NRC of 2019 becomes a fairly uncertain issue. Now people will keep challenging their exclusions through civic society outfits, through NGOs, through different channels. This will lead to further overburdening of the judiciary. And the whole process of re-verification is a fairly complex process. So it isn't as if the NRC was conducted in a flawless manner. There were several procedural errors which were also reported. Okay. Which also means that we must solve for the future before we deal with the present. Number one, we must start diplomatic engagements with Bangladesh to figure out if we are actually going to do this. If the court upholds it, then how are we going to look at the deportation? Second, it would be unfair for one state to bear the burden of these so many lakh people in detention centers. If various state governments could collaboratively work together as a strength of federalism, it could really help. Third, you have to make a digital record of these people so that they don't get citizenship anywhere else if this is the law as it remains. And at the same time, we have to try and emancipate and empower these quote unquote illegal migrants so that they can at least work and earn a living in a monitored enclosure. Otherwise, it is a massive financial and a developmental cost for the people. Now, this entire process has a certain set of advantages and a certain set of disadvantages. When we are bringing so many people in India due to the Citizenship Amendment Act, no doubt we are giving a safe haven. We are reducing their wait time. It is also going to help the government distinguish between citizens and non-citizens so that public welfare schemes are appropriately targeted. But at the same time, India already has a population problem we're already struggling to provide for everybody we should provide for. And second, this migration is not going to evenly happen in the country. This migration is going to happen concentrated in a few states in the country. And thirdly, we are fundamentally discriminating on the basis of religion, which is not an appropriate way to go. And ultimately, we're asking for citizenship documents. Very difficult for poor people to have citizenship documents locked up in their houses. So this is essentially how it works. As of today, the NRC has not been conducted any further. There is no talk about an all India NRC at the moment. But let us understand, how is it going to function? What is the current state of affairs? And how is it being challenged in the court? So, several hundred petitions were filed in the Supreme Court. Several hundred petitions were filed in the Supreme Court challenging the Citizenship Amendment Act of 2019. The Supreme Court has clubbed all those petitions. And the UN High Commission for Refugees has also petitioned the Supreme Court a year or so ago, expressing their concern over the Citizenship Amendment Act of 2019. So not only is this a local or a national issue, it is now definitely a matter of international spotlight. Now, of course, this is a case in the Supreme Court. So what is the name of the case? The name of the case is Indian Union Muslim League versus the Union of India. Indian Union Muslim League versus the Union of India. This is the case. There are several parties. For example, you have Mahua Mitra, Jairam Ramesh, Asauddin Owaisi, Deb Mukherjee, who's a retired diplomat, Tehseen Poonawala, Ashwani Upadhyay. There are several parties to these petitions, several parties. Several hundred petitions have been filed. Now, this is, of course, before a two-judge bench of the Supreme Court at the moment. And there are essentially 4 key issues that have been identified. First, does the CAA of 2019 violate Article 14 of the Constitution, which is the right to equality, by failing the reasonable classification test? Reasonable classification means that if you're creating groups and subgroups, this has to be done with the degree of intelligible differentia. There's a 1981 case also. The way you are grouping them and the reason why you're grouping them should be justified. You will understand reasonable classification and intelligible differentia when we study Article 14 in a fair amount of detail. So that's one. Second is, does the Citizenship Amendment Act of 2019 discriminate on the basis of religion? Discriminate on the basis of religion. Third, does the Citizenship Amendment Act of 2019, because this is an overarching provision, does it violate Article 21, the right to live with dignity as guaranteed under the Constitution? Okay. And fourth are some of the government orders which are issued constitutional for the same reasons. These government orders were issued to implement certain provisions of the Citizenship Amendment Act. Are they also constitutional or not? These are the four primary issues that have been identified. Okay. Now the timeline is extremely clear on these fronts. The timeline is that in December 2019, CAA 2019 was passed. This act was officially notified in Jan 2020, which means this was notified for implementation under the provisions of the act from January 2020 onwards. I think it was the 10th of January, if I remember. Now, as soon as the bill was passed, the Indian Union Muslim League had filed a petition under Article 32, challenging, of course, the constitutionality of it, largely based on it violating Articles 14 and 21. As I was telling you, Article 14 guarantees all persons, citizens and non-citizens, equality before law and equal protection of law. We will do this in a fair amount of detail under Article 14. There is a Supreme Court case called R.K. Garg versus Union of India of 1981, where the Supreme Court had very clearly established that Article 14 stops the Parliament from making any law which arbitrarily or irrationally discriminates between groups of persons. Now, how do you know something is an arbitrary disqualification or an arbitrary classification? The Supreme Court in this case developed the reasonable classification test. It said that the reason, and the test had two steps. The first test, the first part of this test was the reason under which the groups of people are being classified should be based on something called intelligible differentia. Now, the second step was this differentiation should be in relationship, or this differentiation should be towards the larger objective of the act itself. Now, you must understand that the objective of the Citizenship Amendment Act is to facilitate or accommodate people facing religious persecution. Now, the people who have challenged this law are primarily saying that the changes that have been made do not have a functional relationship or do not really solve the problem of saving people with religious persecution. Because a person of a specific religion and a country of origin does not necessarily lead to a reasonable classification. A simple way to understand is there are illegal migrants who have fled to India after facing religious prosecution in Sri Lanka, but the CA does not talk about them. And therefore, if you haven't taken care of all the areas, there is an objection on this. It is because of this, the primary argument is based. Now, apart from this, the central government in 2015 and 2016 had actually issued certain notifications, certain orders on the same grounds, right? That is why the fourth key issue has been identified, where you could exempt certain illegal migrants from 6 religions and 3 countries of origin from deportation or detention under the Passports Act of 1920 and the Foreigners Act of 1946. Now, in 2022, in the month of May, the government issued an order under a provision called Section 16, which you don't have to remember. Under that, the government of India, the central government, issued an order to 13 district collectors of obviously 13 districts with a high migrant population, to start accepting citizenship applications. Remember, I told you, your citizenship applications either are filled online or are sent to the district collector from the same 3 countries belonging to the same 6 religions. And in June, the Indian Union Muslim League has filed for an interim stay on this order as well. So this is the current state of affairs in the matter. Now, do you really need to know all of this in a fair amount of detail? No, but this is where we are. Now, let's come back to our primary use cases of our entire discussion. Article 14 and 21 and religion is a rights issue. Not taking into consensus the states and the impact on the states is the federal issue. Local tensions, communal tensions is an internal security issue. Migrant population and the welfare and the development of them is a developmental issue. And is this the right way to go about it? To my mind, legally, I do not think there is a problem with the act. But morally, it could be argued otherwise. And if I have to make a prediction, when the case finally gets decided, to my opinion, the Citizenship Amendment Act will be upheld. It will not be declared unconstitutional by the Supreme Court. I don't think so. But we'll wait for time to come and we'll see if the Supreme Court does and what are the grounds around it. So this is all you need to know as far as the Citizenship Amendment Act is concerned, and to the extent of which there is a context. Thank you for watching. Welcome to lecture number 3 of theme number 2 of topic number 1, wherein we're going to be covering 3 subtopics. Subtopic number 2, 3, and 4, wherein we're going to understand the policy layout for union and its territory. We're going to understand external and internal changes and the procedures that are required to make those changes as per the Constitution and affiliate laws. As discussed in the outline, the relevance of these topics have already been explained to you. So therefore, it is prudent enough for us to directly move into the substantive portions of the lecture. Now, when we are referring to what are called the policy layouts, let's understand exactly how this works. As we've clearly understood so far, that when the Constitution refers to union and its territory, it is largely referring to a geopolitical setup, wherein it's referring to physical boundaries which create political units at a national and at a subnational level. Now, legally speaking, the Constitution under Part 1, the very first part of the Constitution, refers to union and its territory. And this particular part, therefore, has about 4 articles. And out of these 4 articles, 2 articles also correspond to 2 schedules attached to the Indian Constitution. So therefore, when we are referring to Part 1 of the Constitution, Part 1 of the Constitution largely has 4 ramifications. And the 4 ramifications that we are looking at are Articles 1, 2, 3, and 4. So let's understand exactly what they are so that it's easy for us to put a hang on it. So as I said before, we've got Article 1, Article 2, Article 3, and Article 4. Now, Article 1, as we understand it to be, is essentially an introduction article, which has 2 very important implications. The first, it has a federal implication, and it demonstrates a unitary nature in our federal structure. And second, it identifies the types of territories that exist in India. Articles 2 primarily refers to the changes that are of an external nature and the process behind it. Article 3 refers to changes which are of an internal nature and the process behind it. Article 3, no doubt, is a lot more detailed than Article 2, given the fact that you require a lot more finesse in executing internal readjustments within the framework of the country. And Article 4 gives you certain terms and conditions and certain implications of those changes. Now, out of these 4 articles, as I have mentioned before, 2 of these articles have an implication on 2 schedules. So the idea here is Article 1 leads to the creation of what is called Schedule 1. And Article 4 will have an implication on Schedule 1 as well as Schedule 4. So this will have an implication on Schedule 1 as well as Schedule 4. Schedule 1 is nothing but a list of states and union territories with their areas. Now, numerical figures with respect to their areas are not mentioned, but the districts and the general locations of these areas is sort of mentioned in the first schedule. And Schedule 4 refers to the number of seats that each state will have to the Rajya Sabha. Now, you will understand the implications of it in a few minutes from now. Let us begin with Article 1. Let's understand what it says, and we'll also spend some time on the debates that happened in the Constituent Assembly in and around Article 1. So, for greater clarity and for a select few articles, I am actually enclosing the actual formal text of Article 1, which is in the Constitution of India. So we are looking at Article 1 before us. So let us see what Article 1 tells us. The title of Article 1 is Name and Territory of the Union. The very fact that we have used the word union in a way enforces rule number 2 that we've discussed in Golden Rules, which is the center is stronger than the states. Now, Article 1 has three clauses. So the first clause of Article 1 is India, that is Bharat, shall be a union of states. So it mentions the word India. It also mentions the word Bharat. But most importantly, it refers to India as a union of states, which again signifies that no state in India has the right to leave India. In fact, India is one of the few modern day democracies in the world where the regional units or the provincial units or the states have not been constitutionally guaranteed or have not been empowered in any manner to essentially secede from the country. For instance, if we could correlate it to an international happening, one of the states of Ukraine used to be called Crimea. So Crimea left Ukraine and then joined Russia, which basically means Crimea had the power to leave Ukraine and then join Russia. Indian states do not have that power. No Indian state, no matter what, how, what kind of a special status, what kind of powers can be given to them, under no circumstances have any authority to decide whether they want to be a part of India or not. And therefore, India is appropriately and accurately referred to as a union of states. We're going to come to some of the discussions around it. Now, Article 1, Clause 2 says, the states and the territories thereof shall be specified in the first schedule. This reinforces what we were discussing in the layout of the Constitution, that an article refers to the creation of a schedule and not vice versa. An article can exist without a schedule, but a schedule cannot exist without an article, no matter what the case might be. So therefore, the first schedule will have a list of states and a list of union territories with their appropriate areas and the laws that help you govern it. So that becomes an important part. Then Article 1, Clause 3 explains that the geopolitical territory, the territory of India, shall comprise of the territories of the state, the union territories specified in the first schedule, because union territories were eventually created or carved out later, and any such territories that may be acquired later on. Not that we do not have any enclaves, we do not have any exclaves, we do not have any such sort of special arrangements like countries like China, Hong Kong, Macau. They have the kind of relationship the country of China has with Hong Kong and Macau. We don't do any of those things. We have a very simple arrangement that India has a central government, has a state government. So India, of course, has provinces. But this provision was largely made to future-proof the Constitution. And this provision, therefore, also adds to the belief that the Constitution was made indeed by a certain set of individuals who were truly visionary in nature, that tomorrow in the future, if we decide to have any such kind of special arrangements, the Constitution fundamentally guarantees that to happen in the first place. So this is essentially what Article 1 is. Now, as I was telling you, Article 1 directly refers to the creation of the first schedule. And therefore, I'd like to also show you what exactly does the first schedule look like. These images that you're seeing are the official text of the Constitution, as published by the Ministry of Law and Justice, the Department of Legislations, and this document is available on legislative.gov.in, and the government at least twice a year updates the version of the constitution and publishes it online, and this version is latest dated for May 2022. So the first schedule of the Constitution, which contains a list of states and union territories, it also mentions that the Article 1 and of course Article 4, and we're going to come to why Article 4 later on, but Article 1 allows for Schedule 1 to exist in the first place. The states are rather arranged in an alphabetical format. Then towards the latter end of it, the newer states have been added, but they were originally arranged in an alphabetical format. So of course, Andhra Pradesh happens to be one of the first states. In fact, not only from an alphabetical point of view, Andhra Pradesh historically was one of the first states to be made a state on a linguistic criteria, and therefore there was a socio-political movement backing it. But that's again not the concern for our studies of polity. But if you see specific statistical figures in terms of X hundred or X thousand square kilometer area, none of that is mentioned. What is mentioned is that a law which allows for this to happen, and the areas mentioned in that law must be mentioned here itself. So that's the purpose of the schedule. Now, having said that, this is what is essentially Article 1. Article 1 essentially sets the tone for the country to exist as a whole. But it is also at the same time that we must understand that Article 1 has a fair degree of history behind it, and Article 1 has a fair degree of debate that happened in the Constituent Assembly. So, when the draft of the Constitution was being prepared, Article 1 was worded differently. The original Article 1, and this is not relevant for your exam, this is just to give you a little bit of context. The original Article 1 had declared that India was a union of states, and then went on to define what is meant by Indian territory. It at no point of time had the word Bharat in it. Now, the first point of issue that arose in the Constituent Assembly was that most members were fairly confused as to why India was being called a union of states, especially when we were giving proper, designated, distinguishable powers to the states. The states would undoubtedly have lesser powers than the center, but the states would have a degree of autonomy. They would function as self-governing units to a very large extent. And therefore, why would we not call India a federation? Because the basic meaning of federation is that a federation is a political system with a bare minimum of 2 layers of government, as we've discussed in our earlier lectures. And therefore, most members were of the opinion that the word federation seemed to be more appropriate and more apt to describe India's political situation. Now, of course, this went on to be a primary area of debate. And the chairperson of the drafting committee, Dr. B.R. Ambedkar, said that the word union of states was specifically used and not the word federation. In fact, it is also a matter of trivia that neither the word federation nor the word federalism, both of these words, are not mentioned anywhere in the Constitution. We are a federation, we have a degree of federalism, but we never use those words explicitly in the Constitution. And the reason behind this is because we always wanted to drive home the point that India is going to have a centralizing tendency. India is always going to be a country where the center will ultimately call the shots or will have the last laugh. And therefore, Dr. Ambedkar explained that the term union of states was being used instead of the term federation because it signified and clarified that the states in India had absolutely no right whatsoever, as we discussed before, to leave India or to secede from India. Secede means to leave a political unit. Now, another debate, which was, of course, not a very legally intense debate, but was a symbolic debate, was that a member of the Constituent Assembly wanted India to be renamed to Bharat. A member of the Constituent Assembly wanted India to be renamed to Bharat. It did not, the person did not want the word India to exist, but the word Bharat. And the reason that the member wanted it to be called Bharat is because the word Bharat had more historical significance, had more historical pedigree. And therefore, if you look at the legal constitutional history of the country, as a consequence of this, another member of the Constituent Assembly then recommended that we should not just use Bharat, we should use India and Bharat both. And then finally, the chairperson of the drafting committee, when the final discussions on the amendment was to happen, said that it will be called India, that is Bharat, is a union of states. Now, of course, there were a few people in the Constituent Assembly, particularly, who found the phrasing or the way the article was written to be a little inelegant, but it was, of course, popularly very, very well received. And therefore, what ended up happening is that the Assembly, the Constituent Assembly, rejected all other amendments proposed by any other member. And the amendment which was proposed by Dr. B.R. Ambedkar that said, India, that is Bharat, shall be a union of states, became what is called Article 1 of the Constitution. And if memory serves me correct, Article 1 was finalized in the month of September 1949. So this is the little bit of history. This is a little bit of context behind Article 1. But what does Article 1 largely tell you? It simply tells you that India is a union of states. It has a political undertone to it. And also, it allows for the creation of Schedule 1. Now that we've understood what is Article 1, we shall now move to understanding Article 2 and Article 3. Now, before we do that, let's get some basics right. What we're essentially saying is that there are going to be two changes to India: external changes and internal changes. Now, when we say external changes, we are saying, for example, let us say this is India. And we know India is divided into states and, let us say, union territories. So state 1, state 2, state 3, state 4, state 5, UT1, UT2, union territory 3, and so on and so forth. So an external change would basically mean bringing a part of land, bringing territory which does not exist in India, and basically adding it to India, right? Basically adding it to India. Now, even if you are adding it to India, one out of the following things is going to happen. Either you're going to add it to an existing state. I'll write it a little more clearly. Either we're going to add it to an existing state, or we're going to add it to an existing union territory, or we're going to create a new state with this territory that we're getting from outside, or we're going to create a new union territory. These are the four most likely outcomes that are going to happen. Now, in either of these four outcomes, you are basically changing the nature of the states and union territories, which means if you're adding a new state or adding to an existing state, no matter what it is, it will still have an effect on Schedule 1, because Schedule 1 has a list of all states and union territories with their respective areas. So even if you're adding something from outside, you're ultimately going to change the dimensions of a state or a union territory. The only difference is that you're adding something. On the other hand, when we say that there is an internal change, what we're essentially referring to is altering the existing status quo. Now, what could this basically mean? This could basically mean that you are not bringing anything from outside, you are simply readjusting what already exists. So what will happen is you will either merge state 1 and state 2 into a new state, let's say state naught. You will either divide a big state into state A or state B. This is a possibility. Or let us say you could merge two states, state A and state B, into, let us say, a bigger state, state C. You could convert a state into a union territory. You could convert a union territory into a state. That is also possible. So these are some of the basic examples, some basic permutations and combinations. There could, of course, be more. And also, for example, you would change the name of the state or union territory. The basic principle here is you are changing the dimensions of territory or the name of the state or the union territory without bringing any international territory or without bringing any piece of territory that isn't already a part of India. That is an internal change. In this case also, you would ultimately affect Schedule 1. So even if you're merging two states into a bigger state, or let us say, for example, you're merging two union territories into a state, or two union territories into a single union territory, or the other way around. A lot of permutation combinations could exist. You would basically change the areas, the names of existing states and union territories, which means if you look at the provisions carefully, if you look at Article 1 carefully, even if I, for example, cut UP into UP and Uttarakhand, divide Andhra Pradesh into Andhra Pradesh and Telangana, whatever it is that we do, I bring an external land from outside, whatever it is that I'm doing, whatever it is, at no point of time is it going to make any difference other than primarily Schedule 1. So the point that we are trying to make here is, which is the underlying part, and that is that all territorial changes, no matter what their nature is primarily amending Schedule 1. All territorial changes, no matter what they are primarily amending Schedule 1. And Schedule 1 is a part of the Constitution. Now, whether this is going to be a constitutional amendment or not, we will see in some time, because it is not going to be one, because Article 4 says so. We'll come to that. But what is it that you are changing because of an external change or an internal change? You are primarily changing Schedule 1 of the Constitution. Now, if you notice carefully, let us take another example. Let us say this is state 1. Let us say state 1 has MP constituency 1, MP constituency 2, MP constituency 3, MP constituency 4. At the same time, it also has, let us say, MLA constituency 1, MLA constituency 2, MLA constituency 3, MLA constituency 4, MLA constituency 5, MLA constituency 6, MLA constituency 7, and MLA constituency 8. Right? Now, this state 1 will have X number of seats to the Rajya Sabha, because this is based on the population of state 1 and the current representative framework. But what if I divide state 1 into state A plus state B? I divide it into 2 states, and each state gets 4 MP constituencies, right? Let us say 2 MP constituencies, which is divided by 2, and 4 MLA constituencies. Each state gets this. Now understand that Rajya Sabha seats or Rajya Sabha elections are conducted by the Election Commission, but it is the MLAs of that state who choose a representative of that state to the Rajya Sabha. So if, let us say, this state has 2 Rajya Sabha seats, then these 8 MLAs are going to choose these 2 people, they could be anybody, from that state to represent that state to the Rajya Sabha. So this state 1 had 2 Rajya Sabha seats based on 8 MLA seats. But now there are no longer 8 MLA seats. We've divided the state, and therefore state A gets 1 Rajya Sabha seat and state B gets 1 Rajya Sabha seat. We simply divide it into 2. Now the number of seats to the Rajya Sabha is mentioned in Schedule 4. So therefore, a territorial change which happened to Schedule 1 also had an impact on Schedule 4. Because due to a territorial change, you also had to change the representative divisions, because representative divisions flow from geopolitical divisions. So if geopolitical divisions change, representative territories change. So a change to Schedule 1 can have an impact to Schedule 4 because the seats change, and Schedule 4 mentions the number of seats to the Rajya Sabha. So this is why you will often notice that Schedule 4 is also referenced in Part 1, which is Union and its territory. So an external change or an internal change, most likely an internal change, will have an impact on Schedule 4 as well. Now that we understand this, we're going to spend some time on Article 2, the changes which are of an external nature. Now, if you've read these portions in your standard textbooks, you're in for a shock, because what the actual constitution says versus what is in the standard textbooks are two completely different things. And that is what we're going to draw our attention to. So we will now look at Article 2 and figure out what is it that is mentioned under Article 2. So the title of Article 2 is Admission or Establishment of New States. When we use the word new, it means territories that were not a part of India. It is what is implied and understood as an explanation to Article 2. Now, each word has a significance. The very first word, the Parliament may by law admit into the Union, which means the decision to do this, the power to add new territories that are not a part of India, lies only and only with the Parliament, which is nothing but an explanation of rule number 2, center stronger than the states. For example, the state of Madhya Pradesh does not have any power to have an island in the Bay of Bengal added to Madhya Pradesh's territory, or for that matter, Orissa. The power to add territories which are not a part of India to India will lie with the Parliament. And this will be done by law. This has to be done by law. Now, which means the Parliament has to necessarily make a law which allows for this to happen, which means eventually the change will happen to Schedule 1 and in a rare case Schedule 4, but this can only be done through a law. Eventually, all will lead to a law. You cannot do it through a simple order. You cannot add an island off the coast of West Bengal to West Bengal by just a simple order and not pass it through a law. The decision can be made by an order, but the Parliament must also accept that decision by passing it. That's the key behind it. So the Parliament may admit, establish new states on such terms and conditions as it deems fit or as it thinks fit. So what are the reasons? What are the criteria? How are you going to accept a new foreign land in India or a foreign land to India? And what is it that you're going to use? Are you going to conduct a referendum? Are you going to conduct a plebiscite? Are you simply going to tell them to come over? Are you going to forcefully take it over? Will there be an act of hostility? Whatever the conditions might be, whatever they might be, they will be completely decided by the Parliament of India as the Parliament deems fit, which is exactly why it has been left so open-ended, which is also why the Supreme Court had to intervene and interpret this provision to allow for some clarity. So when we are saying you can admit something in the union, when you can add a foreign territory, what does that basically mean? So when we are referring to external changes, right? When we are referring to external changes, what are the different ways in which foreign lands can become a part of India, or a part of India can be given to a foreign country? There are essentially three that come to mind. One is called ceding. The second is called settling. The third is called claiming. Now, there is a fourth one, but it is not used. It's called conquest. Now, I'll tell you the meanings of each of those. So the difference here is when we use the word ceding, what does that mean? Ceding essentially means an international transfer. Ceding essentially means an international transfer of an undisputed territory. An international transfer of an undisputed territory. We're ceding a territory to another country out of goodwill, out of settlement, whatever it is. We're doing it out of our own will. This piece of land belonged to us. There were no two questions about it. We are willingly giving it away. That's a form of an external change. The second is settling, which is an international transfer of a disputed territory, where India recognizes that this particular piece of territory is disputed and we are settling it. Either we're getting something or we're giving it back to somebody. The third, which is unclaimed, is an international transfer of an unidentified or an ungoverned land. Nobody has taken a claim on this territory. You have to say the sea levels have fallen short and now suddenly an island has appeared out of nowhere. Then let us say you're claiming it by certain procedures. And conquest is an international transfer by force or by war. Now, this, of course, goes against Indian foreign policy. We've never, ever executed conquest as a matter of first resort, and therefore it does not really matter. Now, these are the four different ways through which external changes happen. Now, the idea here is, and we'll come back to the basics, what we've understood so far is that any change that we make, any change that we are making, ultimately is a change to Schedule 1. Now, Schedule 1 is a part of the Constitution of India. And therefore, a change to Schedule 1 should be a constitutional amendment. But it is not. It is not a constitutional amendment because Article 4 says so. Article 4 says any change that you're making because of Article 2 or Article 3, though it is a change to the Constitution, it will not be considered a constitutional amendment. And therefore, this will require a simple majority. And Article 4 very clearly says will not be considered an amendment under Article 368. If you could recall the applications of laws to majorities, you would remember this, and we've discussed this before, that either it is an amendment under 368 with ratification, it's mentioned under 368, either it will be categorically written it is not an amendment under 368 at all, which will require a simple majority. Otherwise, it will be assumed to be a special majority without state ratification, which is special majority 2. So this is one of the ways in which this happens, right? So therefore, what we're essentially looking at is what is called a non-constitutional amendment, because Article 4 clearly says so. So when we're referring to Article 2, we're referring to international changes. None of these changes will be a constitutional amendment under Article 368. This was the norm. But if you think about it, there could be a case where ultimately, if you're adding a foreign territory, you're adding it to a state or a union territory. And even if you're giving away territory to a foreign country, you're taking away from a state or a union territory. So the gain is for a state or a union territory, so is a loss. And these gains or losses could be done by a simple stroke of the parliament using a simple majority, and they would not even have the dignity to call it a constitutional amendment. This is a blatant application of rule number 2, which is center stronger than the states. So therefore, if you are giving away territory which is not disputed, you are adversely affecting the interest of the states in one way. You are affecting the federal balance. So therefore, the Supreme Court interpreted one of such terms and conditions of ceding. And therefore, the Supreme Court said, in the case of ceding, and the judgment was the Berubari Union case. This was essentially about territory which was disputed between India and Pakistan back in the day, of 1960, where the Supreme Court said, if it is a case of ceding, it will be a constitutional amendment under Article 368 without state ratification, which basically means it will require a special majority 2. Why is that the case? Because if we gave ratification to the states, it wouldn't make logistical sense, because you're only affecting a specific state. So you do not need to take the consensus of more than half of all the states and union territories with legislatures which are present. So that's the first reason. The second reason is, we understand that the center is being stronger than the states, but we cannot overcompensate the states, and therefore it has to be a hollow candy. And the hollow candy is, you just require a higher majority, but only in the parliament. And that was also the thought and the rationale given by the Supreme Court in the Berubari Union case of 1960. So put this simply, any external change to India, except a case of ceding, will change Schedule 1, but will be done through an ordinary law, and that ordinary law will require a simple majority. But if it is a case of ceding, in that case, it will be a constitutional amendment under Article 360, therefore making sure that this is of some substance. So if we go back and we fix our table that we've been trying to make, this means when you're talking about external changes, there are essentially, the background is that the parliament decides. Now, we generally identify it as ceding, settling and claiming. So for example, in the case of ceding, you would require a constitutional amendment under Article 368. In the cases of settling and claiming, the government or the concerned ministry, it's usually the Home Affairs, will pass an order, and that order will require a change in Schedule 1 because you're changing the areas, and therefore that will be passed by the Parliament through a simple majority. It would be an ordinary law. Now, of course, we are going to spend some time on understanding some of the case studies of ceding. We'll try and understand exactly how this functions, what are the general ramifications of it. We'll take some examples out of it, and we'll try and figure out exactly how this runs. Okay, so this is the basics of Article 2. We've got ceding, settling, and claiming. All of this is decided by the Parliament, and the Parliament is completely free to decide what it wants to and how it wants to. It's just that it has to be done through a law eventually and finally. The Supreme Court has given an interpretation to Article 2 in the Berubari Union case and said, if it is a case of ceding, it will require a constitutional amendment under Article 368. For everything else, it will not be needed. For everything else, you will simply require what is called a simple majority, which is to be done in a certain manner, right? A simple majority, an ordinary law executed in a simple manner. So this is what is Article 2. Now we're going to be looking at two case studies with respect to Article 2. The first case study that we're going to be looking at is the case study of Sikkim. We'll understand how Sikkim becomes a part of India. The second case study that we're going to be looking at is the case study of the land boundary agreement between India and Bangladesh, and how that becomes essentially also an issue of an external change. Now, if you noticed, when we were looking at Article 2, you noticed there was something called Article 2A, seeking to be associated with the Union. Now, we're going to exactly be discussing this as a matter of our case study. So let's spend some time on the Sikkim case study first, and then we'll, of course, look at the enclaves case study. So when we begin the Sikkim case study, the first thing that we must understand is that A, it is a significant overlap with contemporary Indian history, and the specifics of it are absolutely not relevant as far as your exam is concerned. Now, the interesting part with Sikkim is that Sikkim presents an outstanding story of geopolitical developments, of historical developments, which have had a significant role in what Sikkim is. And the journey for Sikkim to become a full state of India isn't an easy one. And the journey for Sikkim to become what it is today has a lot of ethnicity, colonialism, neighborhood tensions, and so on and so forth, which have, of course, had a role to play in what Sikkim has become and how it is. So let's understand the story of Sikkim. Let's figure out why is it that Sikkim becomes extremely important. So let's begin. To give you an understanding of the most important events or phases that made Sikkim what it is, are these 7 things. The background is that Sikkim was a monarchy. This is extremely important for you to understand. that Sikkim is a testament of transformation from monarchical form of government, absolute monarchy, to a democracy. What we're essentially looking at is transformation of monarchy into a democracy. The dynasty, the monarchical family that we are referring to, is the Namgyal dynasty, and the kings of the Namgyal dynasty were called Chogyals, right? And that's the basic essence behind it. So the story starts from there. Then we see some interactions that happen between Sikkim, Nepal, and Britain, as a result of which Britain and Sikkim become friends, and Sikkim is protected by Britain. Britain, being Britain, starts interfering in Sikkim's affairs, and parallelly, the ethnicity angle comes in, wherein Dalai Lama flees Tibet and comes to India and is, of course, the representative of the Buddhist culture all across the world. And Sikkim, of course, has dominantly been Buddhist. Now, of course, the independence happens, the British leave the area, and from being a protectorate of the British, Sikkim becomes a protectorate of India, is still a monarchy. Then slowly, democratic movements begin in Sikkim. It becomes an associate state of India, and that is done through the 35th Constitutional Amendment. And that is why Article 2A was originally inserted. And then from an associate state, wherein it had a few relationships, it became a full state. So you had to remove Article 2A, which gave certain special provisions to Sikkim. And then you required the 36th Amendment to remove the 35th Amendment provisions and instate Sikkim as a full state. So that's the basic context, the summary of Sikkim's case study. But we will, of course, get into the details of it because honestly, they're fairly interesting. So as I was telling you, the origins of the Sikkim case study are with the Namgyal dynasty. And of course, the context is that I think on the 16th of May 1975 is when Sikkim officially became the 22nd state of India on the 16th of May 1975. And till 1975, in some form or another, the Namgyal dynasty was ruling over Sikkim. And Sikkim wasn't just the small state of Sikkim as you know it to be. There was a point of time in history where the kingdom of Sikkim, as we would know it to be, included the Chambi Valley, which is of course in China, and Darjeeling, which is of course a part of India. And this goes way back to the early 1700s and 1800s. The first ever king of the Namgyal dynasty, Fanseong Namgyal, the image that you see here is of Fanseong Namgyal, was the first ever recorded king or the monarch, who was, of course, eventually the dynasty ruled till 1975. So what happened was, in the early 1700s, this particular region of Sikkim, Chumbi Valley, Darjeeling, which was all one unit at that point of time, saw a series of conflicts between Sikkim, Nepal, Bhutan, and Tibet, which therefore eventually became a smaller Sikkim. Territories were lost, dynasties fought with each other. So that has largely been the context of it. And it has not been a very happy beginning of all of this. Now, of course, the British arrived. Now, you must understand that when the British arrived in India, primarily through the company became the East India Company becomes the company then, of course, transfers the rule to the crown. But when the British arrived, their expansion plans in the Indian subcontinent were heavily including controlling the Himalayan states, largely because of strategic and resource regions. Of course, while the British wanted to do this, the Nepali kingdom also wanted to expand its own territory. So what happened in 1814, from 1814 till about 1816, was the Anglo-Nepalese War. This was a war between the British and the Nepali kingdom. And this war was also commonly called as the Gorkha War. And therefore, this was fought between the Gorkhali army and the East India Company. Now, both sides had very, very strong ambitions, very, very strong plans to expand and to gain strategic control of the mountainous north of the Indian subcontinent. Of course, what happened later is that in 1814, Sikkim allied with the East India Company in the latter's campaign against Nepal, because Nepal has been fighting with Sikkim historically. So Sikkim thought this was a good opportunity, that the enemy of an enemy is a friend. They applied some logic, and therefore uh, colluded with the British, and therefore eventually the East India Company won the Anglo Nepalese War, or the Gorkha War. And as a result, as a gesture that they were supporting them, restored some of the territories that Sikkim had lost in the 1700s, that Nepal had sort of taken away from them late in the 1780. So of course, Sikkim thought they had found a new friend in the British, but of course, it wasn't as simple as it is going to be, because there was a turning point. And that turning point was the British never played their cards straight. The British aligned with Sikkim so that they could eventually have some domination over Sikkim. And that turning point, as we would know it to be, is the appointment of somebody called John Claude White, a civil servant in British India who in 1889 was appointed as the political officer of Sikkim. It was not supposed to mean anything, but eventually what had happened was Sikkim became a protectorate of the British, because there was a treaty that was signed between Sikkim and Britain called the Treaty of Thomlong in 1861. And therefore, this person would now induce some major changes. So what happens is that by around this time, a lot of this Indian subcontinent that British had, which was under their administrative control, the kingdom of Sikkim was no different. It was supposed to be a protectorate, which basically meant that Britain is going to provide armed support, military support, ever Sikkim was in threat. But it turned out that it was Britain who was eventually trying to run the administration in Sikkim. Now, the problem was the monarch, the Namgyal monarch, could not criticize or could not openly say bad things about the British, or wage a voice of war against them. But the monarch of Sikkim took this opportunity and said that because of all of this, there is a massive influx of Nepali migrants into the Sikkim kingdom. Now, Sikkim was dominantly Buddhist, and of course, the monarch was Buddhist, and the migrant population predominantly may have not been Buddhist. They could have come from different ethnicities, including Hinduism, and so on and so forth. So the reason wasn't actually very complex. It was a very simple reason, because of which this political issue now becomes what is called an ethnic issue. and this continued for some time. Sikkim slowly started shrinking in its powers, in its abilities, in its chances to be what it is. And then, of course, by around that time, in a few years from now, India gained independence. Now, 3 years after India became independent, in 1950, Sikkim had become a protectorate of India because the British had wound up and left. In fact, in 1950, a treaty was signed between the Sikkim monarch Tashi Namgyal and the then Indian political officer, which was Mr. Dayal, Harishwar Dayal. Now, the image that you see in front of you is basically this person who's the Maharaja of Sikkim, Tashi Namgyal, the person who signed that treaty, and of course, former President of India, Dr. Rajendra Prasad. Right now, the geopolitical changes that were happening around that time. Right now, the basic idea was when that treaty was signed, the treaty had a very clear understanding that Sikkim will continue to be a protectorate of India, and subject to the provisions of this treaty, the clauses of this treaty, Sikkim will enjoy autonomy in its internal affairs. India is not going to interfere. But this was going to be affected largely because of certain geopolitical changes. And one of those geopolitical changes was that China invaded Tibet in 1949. And Nepal's attacks on Sikkim throughout the kingdom's history were recited and recited over and over again why the kingdom needed a powerful ally. It was only a matter of time, is what Sikkim thought. They thought there could be a certain degree of threat. And once China arrived, invaded, there were talks of the persecution of Tibetans. The monarch of Sikkim thought there is going to be a problem. What happened to Sikkim? What happened to Tibet? We could be next. Now, you must understand there is a very strong ethnic undertone here. See, Sikkim's ethnicity, if you could understand it to be, is largely divided into three: the Bhutias, the Lepchas, and the Nepalis. So, Bhutias and Lepchas, who are dominantly Buddhists, started feeling extremely insecure, scared, worried, and threatened by what was happening to their fellow Buddhists in Tibet, which is why things became slightly more complex. And amongst all of this, while Tibet was being invaded, and when China was at its absolute behest, a gentleman called Dalai Lama becomes extremely important. So what happens in March 1959 is that the 14th Dalai Lama, the one that we know, the last Dalai Lama, escaped from Tibet. And the Dalai Lama escaped from Tibet and came to India. Now, of course, once the Dalai Lama reached the Indian borders, his followers, his associates, his entourage, first settled at the Tawang monastery in Arunachal Pradesh. From there, they of course went to Mussoorie, where they met the then Prime Minister Jawaharlal Nehru to further discuss the future of Tibetan refugees on what could happen. Today, the Dalai Lama's dominant primary monastery is in the town of McLeodganj, which is about half an hour away from Dharamshala. Now, what happens because of this is, when India decided to welcome with open arms Dalai Lama, it sent a very strong message to Sikkim that India isn't like China, and India values ethnic tolerance. And therefore, it makes a lot more sense for Sikkim to continue and further strengthen its association with India. It was a matter of time. And this sentiment was largely echoed by, of course, the political elite of that time. Now, the image that you see in front of you is, of course, the former Prime Minister of Burma. I can't remember the name entirely, but it was, I think, U Nhu. This, of course, is our former Prime Minister Jawaharlal Nehru, our Vice President Dr. Sarvapalli Radhakrishnan, Dalai Lama, and of course, Appa Pant, the Indian political officer in Sikkim in 1956, around that time. Just an old photo to make you contextualize things. Now, while all of this was happening, Sikkim had its own internal problems which were brewing. These internal problems that we are referring to were essentially to do with discontentment against the monarchy. So that period between the 50s and the 70s marked a massive sense of growing discontentment in Sikkim. This was largely because of social issues of inequality, economic issues of inequality, unemployment, poverty, and of course, a sense of feudal control because there was a lack of democracy. Imagine having a border with a nation which fought tooth and nail for years and years, becomes the largest democracy, and you are stuck being a monarchy. So what happens is what happens in any country which is not a democracy. Small associations, political groups start coming together. So by the 50s, in fact, 47, 50, you see the first major political party of Sikkim, the Sikkim State Congress, was formed. And it was this political party that started supporting the merger of Sikkim with the Union of India. And this Sikkim State Congress, later, after a few years later, a larger party was formed called the Sikkim National Party, which supported, unfortunately, the monarchy or the independence of the kingdom. So, on one hand, you had the Sikkim State Congress. On the other hand, you had the Sikkim National Party. Now, of course, if the country chose to be a democracy, the powers of the monarch would be reduced significantly. And of course, the last monarch, Thondup Namgyal, as if you would know this person to be, of course, wanted to reduce political and civil sort of liberties. Now, by the 70s, these protests became mass movements. The royal palace was being surrounded by thousands and thousands of protesters. India's help was sought, and India, because it was a protectorate of Sikkim, the monarch had no choice, asked New Delhi for assistance, and finally, an agreement was signed between three parties: the Indian government, the three major political parties, so that the major political parties of Sikkim, the Indian government, and the monarch Chogyal, they all sat on a table and they formalized a tripartite agreement wherein some major political reforms could be taken. One of them was, of course, that elections would be conducted. This image that you see in front of you is with the Sikkim king Palden Thomgok Namgyal, who was, of course, the last monarch, so to speak. His wife, who was known to be an American New York socialist, was also of the view to retain independence of Sikkim, but eventually that phased out. So Sikkim, therefore, had its first set of elections in 1974. None of this is factually relevant for you, wherein the Sikkim State Congress, of course, which was led by Lenduk Dorji, won. It defeated pro-Sikkim independence parties by a massive margin. A new constitution was, of course, adopted. The monarch became very titular, very ceremonial. And of course, the monarch was absolutely resentful. And around that year, India said, you know what, you listen to us, we worked together. And India upgraded the status of the protectorate of Sikkim to an associate state. This was done to the 35th Amendment. And therefore, Sikkim was given one state, one seat, each in the Lok Sabha and the Rajya Sabha. So, Post 1974, in the Lok Sabha and the Rajya Sabha, there was a seat in the Lok Sabha and a seat in the Rajya Sabha, which was given to Sikkim, which was not technically a full part of India. So India comes from a lot of diverse agreements and all of those things. So of course, this utterly upset the monarch and the monarch tried to raise the issue at various international fora and so on and so forth, but eventually it did not happen. Finally, once you were almost an associate state, this part, when you became an associate state, required for the 35th constitutional amendment. And from here, Sikkim became a full state through the 36th amendment, and this was done through referendums. India accepted the result of that referendum. So what essentially happened was that a referendum was held in 1975, where an overwhelming, about 60,000 people voted to be a part of India, and about 1,500 people voted to not be a part of India. And therefore Sikkim's new parliament, which was headed by the Sikkim State Congress leader, proposed a bill that said Sikkim should become an Indian state, and this was accepted by the Indian government, and this was done in the form of the 36th constitutional amendment, because Article 2 says that you can do this. The parliament has the full power to decide the way you want to. And at the end of the day, you're receiving territory which is not disputed, which means it would require a constitutional amendment under Article 368 as per the Berubari Union case of 1960. So this is how Sikkim becomes what it is, and therefore continues to be what it wants to be. So every year we celebrate, I think 16th of May as Sikkim Day, which is a very, very important day generally, because Sikkim is an instrument of great importance from a northeastern standpoint and the general strategic importance of the country. So this, of course, is the Sikkim study. Now, after the Sikkim study, we will also now look at a second case study, which is the enclaves case study, or the land boundary agreement between India and Bangladesh, an extremely important one. And we're going to do that just about now. So we'll move to the enclaves case study. So to understand the land boundary agreement, which also makes us understand Article 2 and how the land boundary agreement between India and Bangladesh essentially led to the constitutional amendment number 100, is an interesting case study to look at. So we've understood that Article 2 basically empowers the parliament by law to admit any new states in whatever manner the Parliament of India deems fit. Now, the land boundary agreement between India and Bangladesh, of course, is historically very sound, largely because this is an amalgamation of issues that both of these countries have been facing for an extremely long period of time. What is very interesting to note is that the land boundary agreement between India and Bangladesh is actually a combination of three different kinds of land issues which were faced by both of these countries. The three issues are: one of enclaves, second of adverse possessions, and third of undemarcated areas. And we will discuss them in a specific order. We'll first understand adverse possessions. So if you see, if this is a boundary between India and Bangladesh, and the boundary between India and Bangladesh has not particularly been very structurally sound, in fact has been fairly marshy in its own right, as a result of which there were several issues or several instances where a bunch of Indians transgressed this property, this land, and moved to Bangladeshi land, and a bunch of Bangladeshis transgressed that international boundary and moved into Indian land. Now, there is no doubt that this land belongs to Bangladesh, and there is absolutely no doubt that this land belongs to India. But because the people were living there for decades together, they were culturally more synonymous with their regions. So both the countries in their goodwill gestures decided that this land would therefore be given to India, and this land would be given to Bangladesh. Now, why does this become important? Because whether it was this particular land or this particular land, both of these lands were undisputed lands. And you were essentially transferring undisputed lands, which becomes a classic case of ceding, which, as per the Berubari Union case, requires a constitutional amendment under Article 368 without state ratification. So this was one of the reasons. Undemarcated areas is a classic case of claiming, which does not require a constitutional amendment, but an executive order, which therefore has to be passed in the form of a law by the parliament to make the changes in Schedule 1. So undemarcated areas did not require a constitutional amendment. Adverse possessions did, and so did enclaves. But enclaves are a fairly interesting geographical or a geopolitical phenomena to study. And because of this, because of enclaves and adverse possessions leading to constitutional amendments, the 100th constitutional amendment was recently passed in 2015. Now, in 2022, when we say 2015, it of course sounds a while ago, but in the span of legal history, 7-8 years is nothing at all. So let's understand what this entire issue has been. To understand enclaves, we must first understand international borders. Now, you see, international borders can sometimes be very clearly defined. For example, between US and Mexico, as you can see here, this is very clearly US's territory. This is very clearly Mexico's territory, right? And of course, the former president of the United States wanted to build a wall around it. And sometimes you will see international borders crossing through townships, through structures, and so on and so forth. Efforts have been made historically to make international boundaries maneuver through geographical phenomena such as a mountain or a lake or an ocean. But usually what ends up happening is that there are some gaps in the picture. Now, how does this have anything to do with an enclave? An enclave is basically a very special kind of an international boundary. Let's understand this. So an enclave is nothing but a country, or especially an outlying portion of a country. The key word is entirely surrounded by the territory of another country, entirely surrounded by the territory of another country. So if this is country A, and the entire country A is surrounded by one country called country B, then country A becomes an enclave of country B. See, country A is landlocked, no doubt. But if you're landlocked by the same country on all four sides, then you're an enclave. The other extreme to enclave is an oxclave. An oxclave is a portion of a country which is geographically separated from the parent country and is surrounded by different countries on all four sides. So if you're landlocked from all four sides by different countries, and a part of your main country is geographically separate, like in this case between A and Y, then Y is an oxclave of A, where in the first figure, A is an enclave of B. And this is what makes Bangladeshi territorial issues far more interesting. So what ends up happening is, throughout the world, there are only 3 such enclaved countries where an entire country is surrounded by another country on all 4 sides. The Vatican City, San Marino, and Lesotho are the examples of fully enclaved countries. Now, to understand how this sometimes may be a problem, and sometimes this may not even be a problem to begin with, let's take some practical examples. See, what ends up happening is a country A surrounded by a country B is okay, is not a problem, fairly common all across the world. But there are very few examples in the world where this country A surrounded by country B is again surrounded by country A. These, as you can see as the figure represents, are called enclaves within enclaves. And there were 3 such examples in the world: UAE, Oman, Netherlands, Belgium, and India and Bangladesh. This no longer is the case because this has been sorted out, and this has been solved by the land boundary agreement, which India implemented through the 100th constitutional amendment. But what was particularly interesting with India and Bangladesh is, so A inside B inside A is still relatively acceptable. These are called single order enclaves. What was spectacularly peculiar about India and Bangladesh was India, a part of India, inside Bangladesh, inside India, inside Bangladesh. So India, Bangladesh became the only multiple order enclave system in the world. And this was a very complicated affair. See, this part of India is geographically separated from mainland India. So this India A is an exclave of India B, but is an enclave of B, I, and B. So that is why it became extremely complicated. Now, if you compare in India and Bangladesh to a Netherlands and Belgium, you'll understand logistically, cooperation between 2 countries can go a very, very long way. So let's understand this. This is a classic case of Netherlands and Belgium. And these are real-time images where you see, for example, in image number 1, if you notice, the plus sign that you see here is the international boundary between Netherlands and Belgium. And this car is parked across an international border and nobody really cares. If you see this particular shopping store or a grocery store, half of the store is in Netherlands and half of the store is in Belgium. In fact, this house, a part of the house is in Netherlands and a part of the house is in Belgium. In fact, according to international law, wherever is the door of the house is the country where the house is in. So if you want to migrate from a Belgium to Netherlands, all you have to do is change the door. Now, why do such easy, convenient systems of international territories exist in Netherlands and Belgium? Because they are a part of 3 extremely important partnerships: the European Union, the European Economic Area, and the Eurozone. The European Union is a political partnership. The European Economic Area allows for free movement of man and material and no trade barriers. And the Eurozone essentially imposes a common currency called the euro, which basically means for a common person living across Netherlands and Belgium, it really doesn't make a difference because the currency is the same. You're using similar trade systems. There is no difference in ecosystem per se, and life can continue as easily as it could. But this is not necessarily the case with India and Bangladesh. If you see India inside Bangladesh, inside India, inside Bangladesh. Now, why is this a problem? Because if you compare it to Netherlands and Belgium, India and Bangladesh do not have open borders. We have heavily guarded borders because of security and other reasons. We do have what are called pleasant relations with Bangladesh, but they've gone through their share of turbulences. Unlike Netherlands and Belgium, where the enclaves have all facilities, the innermost part of India does not get the benefit of any major government scheme. There is no Indra Awas Yojana, there is no Jan Dhan Mission, nothing at all that actually reaches this particular part of India, which doesn't even feel like India. These guys have been surrounded by Bangladeshi culture. They have, in fact, become more Bangladeshi in their ways and means than they would have ever been Indian. Not only we do not have a similar currency, so there are, of course, issues of economic exchange, and the borders, unlike Netherlands and Belgium, are marshy and therefore are not very clearly marked. And as a result of this, this required an urgent attention. And which is why, for the first time in Indian history, India gave 111 enclaves to Bangladesh, whereas Bangladesh gave about 51 enclaves to India to ensure that if you are closer to territory, it's more synchronous, then take the territory. The people were, of course, asked whether they want to be a part of this country or that, and accordingly, express citizenships were executed through provisions of the Citizenship Act and so on and so forth, which we will, of course, discuss in the second topic of this theme. But the idea is for a country so infatuated with land, for a country which fights so heavily on land, where land has been one of the root causes of major socio-political, legal changes in the country, gave up land because it was in the larger good and the benefit and the utilitarian welfare of the people. And that's what makes the Indo-Bangladesh Land Agreement extremely special. And this is why, when we look at the two case studies as we do, they have a certain premise around it. So this is what is Article 2. Article 2 is all about external changes. It refers to any form. The words ceding, settling, claiming are not mentioned anywhere in the Constitution. Therefore, you will never be asked these words in the prelims exam. All that Article 2 says is the Parliament can admit a new state in any manner it deems fit, as long as it's done through a law. That's all that there is to Article 2. So anything beyond that is a matter of legal commentary, like you and I are currently doing. Now, we will look at Article 3. Article 3, to fairly warn you, is a long article, because Article 3 contains a proviso as well. So what is a proviso? A proviso is a mini schedule attached to the article itself. It is an explanation to the article attached with the article itself. And Article 3 refers to internal changes, changes which happen within the territory of India by rearranging, readjusting, renaming, converting one kind of a territory into another, a state into a union territory into a state. Basically, whatever happens, happens within the boundaries of India without bringing or taking away any foreign land whatsoever. So first, let's look at Article 3. Let's understand what it is, and then we'll understand the Constituent Assembly debate around it, and we'll figure out whether this makes sense and what is the process around it. First things first, you have to remember, Article 3 is far more in depth, in detail, because it has a heavier federal implication and therefore requires a greater unitary bias than Article 2. If you're bringing something foreign into India, it's a matter of naturality that the parliament will have an upper say. But when you're rearranging existing state units or regional groupings, for the center to have a larger say, you're really pushing your federal limits. So let's understand what it is and every word in what Article 3 says it to be. So let's begin. The title of Article 3 is Formation of New States and Alteration of Areas, Boundaries, or Names of Existing States. Who has the power? The Parliament by law. So what does the Parliament do? The Parliament creates a law. If you're making multiple changes to multiple states and union territories in one go, you can do it through a single law. it will usually be called a State Reorganization Act, right? If you are doing a change to a specific state, say the Andhra Pradesh Reorganization Act of 2014, what do these acts do? Both of these acts fundamentally change Schedule 1 and they may change Schedule 4 if there is a change in Rajya Sabha seats. Why are they not constitutional amendments under Article 368? Because Article 4 says so. Article 4 very clearly says that any change to territorial provisions is not a constitutional amendment under Article 368. And then we apply the Supreme Court interpretation to 2 and 4 under Berubari Union, except ceding. That's as simple as it gets. So that is why it's done through an ordinary act, right? Now, what are the different mechanisms that have been given here? The Parliament by law may form a new state by separating a territory from any state, or by uniting two or more states, or parts of states by uniting a territory to a part of any state, which is essentially what we've discussed before. Increase the area of any state, diminish the area of any state. This would effectively mean adding it to something else or reducing it from somewhere else. Altering the boundaries of any state would also mean the same thing, and alter the name of a state. Very clearly, if you're changing the name of the capital of a state, or if you're changing the name of a city, or if you're changing the name of a district, or you're creating a new district, this does not fall under Article 3. The state gets to decide it. The convention is the state decides it. Could be done to the state legislature, sends it to the center, to the Home Ministry for an approval, because the procedures are set that way. But changes to districts, capitals, or cities, nothing to do with Article 3. It only deals with the name of the state and the area of the state. It's that simple. Name or area of a state, or in fact, a union territory. Right? Now, if you notice, this is your simple provision of Article 3. But Article 3 has a provision, as I was telling you. This gives you the procedure as to how it has to be done. And that becomes the important part. So how does that happen? To simplify it, suppose UP has to be changed into UP and Uttarakhand, right? For this, the UP Reorganization Act has to be passed, right? Now, this has to be passed by the Lok Sabha and the Rajya Sabha separately, or in case of a deadlock through a joint session, but we'll come to that later. And this has to be done through a simple majority. But before this reaches the Lok Sabha or the Rajya Sabha, the president has to first recommend it. Now, this might seem a little confusing to you. So let me further simplify this process so that it's a little easy. So let us say I'll use the blank space here. Suppose the Ministry of Home Affairs drafts the UP Reorganization Act, which is to divide UP into Uttar Pradesh and Uttarakhand. That's simple. After this final draft is ready, it sends it to the president. Okay, it sends it to the president. Now, it is the president who is supposed to send it to the Lok Sabha or the Rajya Sabha, and both have to pass it through a simple majority. Now, clearly, this is the center stronger than the states, because you're changing the state. You're dividing a state into two different states, and the people who are deciding it is the parliament, right? Now, this is rule number 2, center stronger than the states. So therefore, hollow candy number 1, the president will recommend it to the House. The president is elected by both the center and the state, so it creates a sense of composure, and whether it is really needed or not, the president can take a call. And before the president sends it to the houses, the president will send it to Uttar Pradesh, and Uttar Pradesh will give their opinion in the form of whether they're okay with it or they're not, and what are their views, do they agree with this or not. The idea here is the president refers it to the concerned states or concerned state for their opinion, but is not bound by it. But is not bound by it. All that the president has to do is ask, but not listen. So this becomes your hollow candy number 2. So basically, the center can split a state into 2. The states are going to say, wait, 1 second, aren't you encroaching my space? Yes, we are. So don't worry. Before the parliament passes it, our president will send it to you for your opinion. The states feel happy. And just when the states are about to give their opinion, the president will keep the phone down. So that is the process behind it. That is exactly what Article 3 is trying to explain to you in a little complicated setup. It's essentially what it's trying to say in a slightly more complicated setup. It's essentially saying that provided that no bill for this purpose shall be introduced in either house except on the recommendation of the president, and where the proposals contained in the bill which affects the areas, boundaries, or names has been referred by the president to the legislature of the state for expressing its views thereon within such a period as may be specified, or further period that the president may allow. But there is no such hard and fast rule on whether they have to listen to it, whether the views have to be given within a period of time. So that is that. So this is what is essentially what is called Article 3, right? Now, from a historical point of view, the original Article 3, which was originally intended to be inserted in the Constitution, had given far more powers to the state. In fact, the original Article 3 was when the states could request for a territorial change. The original Article 3 required that a resolution should be passed by the states through a simple majority for the parliament to consider it or for the president to further forward it. But none of these provisions were actually inserted, and Article 3 in its current form, in its existing form, was therefore given a very, very strict setup, wherein the president refers it to a concerned legislature, doesn't matter what they have to say, and the bill is finally passed by your Lok Sabha and Rajya Sabha. So this is how it actually happens. So therefore, this becomes a very interesting setup from a historical point of view. In fact, there were several members of the Constituent Assembly who were strongly opposed to this idea as well. But such as such, and it is actually because of Article 3, which is why you will see the State Reorganization Act, Andhra Pradesh Reorganization Act, Uttar Pradesh Reorganization Act, as several acts that have been passed. What is very interesting is the J&K Reorganization Act of 2019. which was also done in the same manner. Now, I can understand a lot of you might be confused because you would have heard of something called Article 370. So let me just cut this short and explain this to you. Article 370, in simple words, gave a special status to J&K. What was that special status? The special status was you could not apply anything to J&K without asking J&K. Now, who do you ask in J&K? Rule number one, democratic mandate, the Legislative Assembly of J&K. And if the Legislative Assembly is not there, has been suspended, then you ask the governor of J&K, right? So, Article 370 gave special status to J&K. You wanted to remove Article 370, so you asked J&K, but the assembly was not there. So you asked the governor. The governor is appointed by the president. Rule number 2, center stronger than the states. The governor said, of course. So you remove Article 370 in the sense that you do not, it is not applicable anymore. Is 370 still written in the official constitution? Yes, but it is not enforceable. It is not to be implemented. It is inoperable. It is like an appendix to the human body. So once the protection to J&K under 370 was over, J&K became like any other state. Now you basically had to convert J&K from a state into a union territory with legislature and a union territory without legislature. For this, Article 3 will apply, and you will simply do this by a J&K Reorganization Act of 2019. There is, of course, a lot of politics, there's a lot of legal intricacies behind it, but a simple way to understand is that if the question is, why does it take a simple parliamentary law to convert J&K, a state, into a union territory? This has never happened in the history of the country before. Union territories have been made states, but for the first time, a state has been made a union territory. It's almost like a demotion, because a state is a higher form of a democratic institution than a union territory. So this is largely how Article 3 functions. This is why Article 3 functions the way it does, and therefore this takes care of your internal changes. Now comes Article 4, which are the terms and conditions. Article 4 basically says any change due to Article 2 and 3, which will require a change in Schedule 1 or Schedule 4, will not be considered a constitutional amendment under Article 368. It will be done through a simple majority, no matter what it takes. The Supreme Court interpreted, except for CD, you will require special majority. It will be a constitutional amendment. For everything else, you can continue to call it a simple majority. We have absolutely no problems whatsoever. Now, let's quickly look at Article 4 to understand what is it that we are referring to. See, laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedule. You would now understand why the fourth schedule, because a territorial change will have a representative change, which will therefore affect the number of MLAs, which will therefore affect the number of seats to the Rajya Sabha. And any supplemental, incidental, or consequential matter, which basically says, if there are any changes due to Article 2 and 3, basically anything else in the Constitution that you have to change because of a territorial change will not be considered an amendment under Article 368. So Article 4 Clause 1 says, any law referred to in 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental, and consequential provisions, including provisions as to representation in the parliament, legislature, legislatures of the state, states affected by such law, or parliament as they may deem necessary. So we don't have a schedule which says number of seats to the Lok Sabha. We don't have a schedule that says number of seats to the Legislative Assembly, so it doesn't matter. It's largely governed through Representation of People Act and so on and so forth, or orders of the Election Commission. So basically, any change due to a territorial change will also not require an amendment to to the Constitution under Article 368, which is mentioned under Article 4 Clause 2. No such law, as aforesaid, shall be deemed to be an amendment of this Constitution for the purposes of Article 368. Right? So that is it. And Article 4 Clause 1 says, primarily what it says is, if you are making a territorial change, which requires changes to be made to, for example, Rajya Sabha seats for that concerned state, do it. And such a change will not be a constitutional amendment under Article 368. This is nothing but a domino effect. This is nothing but a domino effect. So these are your provisions. This is essentially how it ran. And therefore, what we have before us are the basic provisions of territory from Article 1 to 4. So we understood that we're essentially looking at geopolitical territories. We understood that there is a classic case of a unitary form of federalism. And we also understand this has rarely been asked in the prelims, but because there has been a question on principles of citizenship, we also have to be prepared for principles of territory. Now, after this, we will study reorganization of states as a case study. And do we need to reorganize India? Are the 28 states and 8 union territories good enough? Are they making governance, administrative sense, or do we need to do something more? So that is the final part of topic number 1, which is regards to territory. Thank you.